guns altogether. Under Heller, the Supreme Court has held that to keep and bear arms means to possess and carry weapons in case of confrontation, which necessarily entails the buying of them for the average United States citizen. Heller says that the very text of the Second Amendment implicitly recognizes the pre-existence rights to bear arms and declares that it shall not be infringed upon. The plaintiff did not identify any law that transforms the merchant into a quasi-judicial fact finder, which proves to a would-be gun owner that they are fit or unfit to bear arms.
Counsel, although that proves that Heller said those things, in this case, both Heller and Bruin were government laws where the discretion was rested within the government. This case, the discretion rests with a private advocate, individual like yourself or your client who own gun stores. Would that make it a little bit different?
It would make a bit of a difference, but it would still be as applied. They are similar enough within to both laws.
And you say that they're similar even, so then in your reading of the Constitution, then, is there a requirement to sell people guns? In other words, if you're a gun store owner, are you then required to sell guns? Does the Constitution then somehow apply to private advocates that way?
Well, Your Honor, the Constitution would apply to private owners since they do follow your constitutional rights. And if you own a gun store, you would be entitled to sell firearms.
Right, you're entitled to sell firearms. I guess my question is, are you forced to sell firearms? If, as you say, the right to sell firearms, so the fundamental right to sell firearms, then is there an argument that you're actually required to sell someone a firearm?
Well, Your Honor, you are not required to sell anybody a firearm, but in this case, it's about it's about entrusting a firearm towards someone. So as applied here.
Right, but I guess my question would be, so your argument, as I understand it, is that the Constitution implicitly has a right to sell arms. It doesn't necessarily require the right to bear arms, correct?
Yes.
So I guess my question is, if there's a right to sell arms, does that also entail a duty to sell arms?
Well, yes, Your Honor, it does entail a duty to sell arms, as the average United States citizens as the average United States citizen will not be able to own a firearm if they are not able to buy one from the merchant.
So I guess my question there is, then if even try to gun club under your rules of Constitution, sell a gun to somebody.
Well, if the person that has survived, especially in this case, it is for self-defense purposes. Now, Your Honor, the plaintiff said that the plaintiff says that the retailer is supposed to deem a person fit or unfit, and this is unconstitutional. As under 2007, there is nothing specific to guide the merchant as to what deems a person to be fit or unfit, and this is placing way too much burden on the merchant.
I mean, counsel, it may place burden on the merchant. It's burden on the merchant through the Constitution. That is what we're here.
Yes, Your Honor, and it would be unconstitutional. It would be unconstitutional, as the burden placed on the merchant should be rather placed on the government. This is a decision that should be placed on the government rather than the merchant and the buyer.
But I thought the whole point of Bruin is that the government found out to make it. On other hand, the government isn't allowed to take a discretionary approach.
Well, yes, but under Bruin, it is also stated that the government was allowed to deem a person and was allowed to deem to what a person's qualifications to own a license should be.
So is it your position that Second Amendment has no selling a gun to a person who the seller knows is a criminal and will commit an act?
No, Your Honor, this is not our position. Rather, it is.
So how's that different from that? How are those two situations of cargo coming in who's unfit, essentially, to buy a gun, and then a plaintiff or someone coming in who knows may commit a crime? How are those two different?
Well, on one hand, if you know that somebody will be committing a crime that is specific and narrow enough for you or for the merchant to not entrust the person with a firearm, but simply in this case, Cantrell had no intention of disturbing the peace. Your Honor, under Bruin, the Supreme Court pointed out that gun licenses must be narrow. The gun license issue must be narrow and follow the right criteria. And here, no definitive list is given as to what that criteria is.
Well, isn't there a list of criteria for unfitness? I thought when I read the ad that it includes being unfit to mean not trained, dangerous, mentally unstable, and such. So to me, that would be a criteria.
Yes, Your Honor, but in this criteria, it is not narrow and specific enough. And it can be up to interpretation for each different merchant, which would make it unconstitutional. There's no specifics as to what would make a person, as to what level of mental health would deem a person unfit to bear an arm.
So is it your position that if it did have a specific, you can't sell to anyone with suicidal ideation, that would be constitutional?
Yes, Your Honor, it would be more constitutional as that would be fit and narrow, and it wouldn't leave no room for interpretation.
So I mean, we kind of are starting to go down the road of horrible interpretation. That's really important based on Bruin and some of the in court cases. So my question to you is, in the briefing, I noticed that there were extensive historical precedent for restricting the use or sales of arms to breach the peace. So how are those laws not sort of the foundation in which this law should be built off?
Well, Your Honor, these laws or these historical positions can be clearly distinguished as it states that you cannot, that a person who is deemed to be a disturber of the peace cannot own a firearm. But under 2007, there is nothing here to specify as to what would deem a person to be a disturber of the peace. 2007 simply states that any person deemed unfit shall not be able to own a firearm.
You can have 2 minutes courtesy. Okay, but so would a disturber of the peace have to, let's say Imperium passes a disturber of the peace law, you would say that would be constitutional? Yes,
Your Honor, if the disturber of the peace has the specifics as to what.
So we believe it specifically listing really all that stands between constitutional law and unconstitutional law and listing of factors.
Yes, Your Honor. And
you don't believe that the factors, because there are factors listed, even though they're not fully explained. That's not the case.
Yes, Your Honor, that is.
So what would look sufficient in your argument? Does it need to be like a point to point, like where you have, so let's say Imperium passes, let's say I declared it was constitutional, and Imperium passes a new law, and they say, before you sell a gun to someone, they must do a 5-hour training. Would that be constitutional?
Yes, Your Honor, as that would be specific and narrow enough, and if there leaves no room for interpretation.
Okay, do you have any other arguments you want to make?
Well, it's fine.
We're doing the first.
Your Honor, again, the plaintiff also did not point towards any historical tradition that punished a merchant for selling a firearm for purposes of self-defense. And in order to justify the regulation, the government may not simply posit that the regulation promotes an important interest, rather the government has to posit that the regulation is consistent with this nation's historical background, which is not the case towards today. In conclusion, the shooting service respectfully requests that plaintiff's motion in limine be denied because under the
one last thing though, you mentioned that there's no historical precedent for this law, but there's also no historical precedent of courts over current laws that put restrictions on sellers. Is that correct?
Yes, Your Honor, that is correct.
Okay. I think that's fine. Counsel, I'm ready to rebuttal. You reserve 2 minutes of time for rebuttal. So you have 2 minutes and you'll have 2 minutes of courtesy time. So counsel, plaintiff will have 4 minutes. Timekeeper, please verbally call out when Carlos' time is expired.
Now, unlike the opposing counsel mentioned, the plaintiff does not have to identify a historical tribal rule that aligns with the act, only a representative historical analog, as stated within the case of Bruin. And within history, there has been times seen where there have been gun laws set in place. This idea was carried into the 19th century with common law offenses and surely statutes which required those who bore guns to post bonds before doing so and forfeit the bond if they breached the peace. These financial incentives for responsible arms carrying.
Also, those financial incentives were borne by the gun holder, who's also the Second Amendment right holder. Is that different from having the responsibility now be placed on the seller of the gun?
Your Honor, this is, well, within the 19th century common law offenses, it is going towards prevention, which is exactly what the act is also trying to implement in some cases.
So would you say it's all true? But I mean, the law in blue was also going and elevate those towards prevention, but those are still sometimes too.
Are you talking about
The law that was overturned by the U.S. and Keller were also prevention acts. They were designed to prevent harm. So I guess my question is, how are those different from these creative peace laws?
Well, like I said earlier, Your Honor, the two laws that were overturned in that case, and I argued earlier with the may issue laws, well, this act is a shall issue law. And so with the shall issue law, comporting to the prevention, it is not meant as any like degree of punishment. And the act simply is trying to, the act is different from the.
Wait, you're saying the act isn't a punishment, but violating the act, then it gets dragged into court as a day. The massive cost and massive negative impact.
Oh, well, what the act is trying to accomplish is when a seller knowingly violated this law, they go to court. And after being found by a jury, after being found by a jury to have knowingly, recklessly sold a firearm in, that goes against the act, that is when the act imposes said fines. But what it is not doing is it's not right off the bat saying, oh, someone violated this law. It has to go through the court system and.
But that can still violate the Constitution if you're taking away from the Second Amendment right inappropriately, even if it does go through a judicial process.
Well, the Second Amendment right is not being taken away, as the Second Amendment specifically outlines an individual law-abiding citizen's right to own a firearm, talking specifically to the buyers. This act really focuses on what the sellers are doing.
So then your argument is there's no implied right to sellers.
Yes, Your Honor, that is right.
So I mean, getting back to historical precedent, to me, there seems to be a significant difference between the breach of the peace law and this law, purely on the basis of the breach of the peace law was specifically for bad acts. This law includes this on things that wouldn't necessarily make someone bad or a criminal act, stuff like not being sane. Does that difference matter at all? And if it doesn't, please explain why.
Well, as this is a similar historical analog, it doesn't have to be a historical claim, Your Honor, but it is different as what.
Right, it doesn't have to be a historical twin, but I'm trying to see, does the difference make it not a historical twin?
No, Your Honor, the difference still does make it a historical analog in today's case. And for the foregoing reasons in the case cited today, the plaintiff respectfully asks to uphold our motion by finding it constitutional. Thank you.
Okay. The court appreciates your hard work in briefing and arguing this issue. In 3 minutes or less, I will issue the court's ruling. During that time, please remain in the room. Remember, you may speak only to students on your team who are participating in this project. Please start the clock and announce in 3 minutes.
No.
Okay. So the court thanks counsel for their argument and is ready to rule. Based on the argument presented today, the court denies the plaintiff's motion in limine. Accordingly, the court finds that 20 Imperial Civil Code, Section 2007, the Responsible Firearms Sales Act, as applied in this case, is unconstitutional under the Second Amendment. So now I'll briefly discuss the argument kind of sort of both more out of character with you guys. I think first that you did both a great job. This is a really complicated thing to argue in front of us. You know, it's the kind of thing lawyers were really highly paid, spend a really long time and build a huge amount of hours trying to figure out how to argue. In terms of areas to kind of work on as you go forward, I think just always make sure you have a little bit more detail in your argument, in your answers to the questions, because that's really important in how you kind of explain it. Again, I understand that like this is really, you know, complicated legal stuff, and for a lot of these questions, there is no good answer. I think, you know, if the defendant, you can really hammer home the fact that this is a lot like real, and you really need to just hammer that hard. And the Supreme Court's been pretty pro Second Amendment recently, so that's kind of more, I think that's the argument. But things aren't totally terrible for the plaintiff. Historical analog stuff is not terrible. There is a pretty big distinguishing fact there with the whole unfit versus bad. But, you know, that's a pretty good one. And then the big thing you have is this is only a Second Amendment issue if you imply a Second Amendment right to the seller. And the U.S. Supreme Court has been become very hesitant to do imply grounds. So that's really, I think, your guys' best argument. You need to really be able to hammer. It's a seller, it's different, it doesn't count as finding it doesn't impact the Second Amendment for that deal, and that because otherwise it looks a lot like Heller, and that's really bad. Like Heller. The Supreme Court pretty definitively ruled it on that. Since the court granted the motion, since the court denied the motion, thus Harvard's second cause of action is dismissed with prejudice and will not proceed at trial. Additionally, exhibits 15, 17, and 18 are excluded from evidence under Rule 402. This concludes the pre-trial argument. The court is ready to move to trial. We're now ready to begin the trial. I'll give the parties the opportunity to handle some brief comments. I'll start with Justice Carter.
Yes, Your Honor. The plaintiff would like to know your opinion on movement about the well.
I think movement about the well, you're allowed to freely move about the well if you wish. You're allowed to approach the witness, but just without asking, but make sure you kind of keep it respectful. You know, I'll step in if anything gets out of line. And ask permission before you approach opposing counsel or the court.
Yes, Your Honor. Additionally, we would just like to point out to the court stipulation 11, which states that both Drew Cantrell and Skylar Pullman are party representatives, and therefore admission by party opponent of the exemption to hearsay does apply to statements made by those two parties. Additionally, we would just like to draw attention to stipulation 12, which stipulates Dr. Morgan Judd as an expert in firearm safety.
Understood.
We have no further pre-trial answer.
Okay, thank you, counsel. Counsel Shooting Star, do you have any help?
Yes, Your Honor, we would like to ask for the preference as the swearing in of the witnesses.
I'll constructively swear in the witnesses as they come in.
Yes, that concludes it. Housekeeping.
Okay. No objections to any of the stipulation stuff?
No objections.
Okay. Before we begin, I'd like to let both parties know that we will take a very brief moment between statements or examinations to ensure our judges have been able to submit their scores and comments in the tabulation software. With that in mind, Counselor Justice Cargo, you may begin your opening statement when ready.
Yes, Your Honor. May I proceed?
You may.
Violations and retention led to the devastation. Members of the jury, let me take you through what happened on May 28, 2022 at Shooting Star Gun. A firearm safety instructor named Drew Cantrell, who violates the very safety rules he teaches, was told to instruct 2 customers, one of which being our client, Justice Carbo. Now, when Drew Cantrell went to fire the arm, he was going to demonstrate how to fire the handgun. However, he lifted the gun, aimed it downrange, and that's when the devastation happened. Justice Carbo was shot in the leg. And due to Shooting Star's negligence, Justice Carbo was involved in this devastation. Now, members of the jury, we the plaintiff hold the burden of proof. That means by preponderance of evidence, or more likely than not, that we have to prove to you either negligent hiring, supervision, or retention of Drew Cantrell. We'll prove that Shooting Star is negligent in the hiring of Drew Cantrell and the retention of Drew Cantrell. We'll do this in 5 simple steps. Step 1, Drew Cantrell was hired at Shooting Star. Step 2, Drew Cantrell became unfit to work at Shooting Star. Step 3, Shooting Star was knowledgeable of the unfitness of Drew Cantrell and knew that it could cause harm to others. Step 4, Drew Cantrell's unfitness directly caused harm to Justice Carbo. And step 5, that Shooting Star's negligence in hiring and retention caused harm to Justice Carbo. But members of the jury, all you have to remember is 3 things: Drew Cantrell's violations, the retention and hiring, Shooting Star, and devastation that included Justice Carbo. Members of the jury, we will meet our burden in today's case. We'll meet it by calling Ross Hernandez. Ross Hernandez will testify to Drew Cantrell's history of incidents and violations at Shooting Star. Ross Hernandez will tell you how Drew Cantrell pointed a gun at another employee on May of 2021. Ross Hernandez will also testify to the fact that in November of 2021, Drew Cantrell brought a loaded gun from the gun range into the shop floor. Then Justice Carbo will tell you what happened on May 28, 2022. Justice Carbo will tell you how they needed a gun because Imperion was getting unsafe. And the fact that they came to Shooting Star. They put their faith in Shooting Star for safety. However, Shooting Star let Justice Carbo down. Justice Carbo was shot in the leg, and this was the devastation. Finally, our expert witness, Dr. Morgan Judd, will testify. Morgan Judd will provide some analysis to what happened on May 28, 2022, and break down all the actions that happened. Dr. Morgan Judd will tell you about the basic firearm shooting rules that every gun range follows, and how Drew Cantrell violated those rules. Dr. Judd will finally tell you about Shooting Star's rules. Now, Drew Cantrell violated some of those rules on May 28, 2022. Cantrell's violations, Shooting Star's retention and hiring, led to devastation. Members of the jury, at the end of today's case, my co-counsel, Charlotte Ton, will stand where I am standing right now, asking you to find Shooting Star liable in the negligent hiring and retention of Drew Cantrell. Throughout today's trial, and at the end of today's trial, when you go into the deliberation room, just remember, violations and retention led to the devastation. Thank you, Your Honor.
Thank you, Counsel. Shooting Star Gun Club, you may proceed when you're ready.
Yes, ma'am. Before I begin, may I ask, I'm feeling this.
Yes, you may. You may proceed.
Accidents happen even with the best of preparation. May it please the court, opposing counsel, members of the jury. My name is Alexa Hernandez, and I, along with my co-counsel, Giovanni Maldonado and Celeste Flores, we are proudly representing the defendant, Shooting Star. You will hear today that Drew Control is an experienced gun user, as they've used guns their whole life. They are a certified gun safety expert and have teach classes in gun safety. Further, you will hear that the accident was Justice Carbo's own fault, as Justice Carbo moved out of position, hitting Drew Control's right arm, causing the gun to drop. The gun malfunctioned due to no fault of Drew Control. The gun had an overly sensitive trigger, causing the gun to shoot twice. You will hear that Justice Carbo signed a release of liability and hold harmless agreement, where he assumed the risk in participating in a hazardous, dangerous activity. Now let's talk to you a little bit about the law. Under the plaintiff's negligent hiring claim, my client is only liable if they knew or should have known that Drew Control was unfit or incompetent, and that incompetence caused a risk to others. Further, they have to prove that incompetence or unfitness caused Justice Carbo's injury. And as you will see, Drew Control is not incompetent, and Justice Carbo caused his own injury. Today, we will call 3 witnesses. First, we will call Drew Control. Drew Control will tell you that he has handled guns his whole life, that he is board certified in gun safety and a certified gun safety instructor. He will tell you, we expect him to tell you today that we expect Drew Control to tell you today that on the day in question, he shot only once, so the gun must have malfunctioned. We expect him to tell you that he did not flinch. Justice Carbo moved out of position, hitting his right arm, causing the gun to drop. Second, we will call Avery Wren. We expect Avery Wren to tell you that every time she bought a firearm at Shooting Star ran a background check to make sure she was fit to buy a gun at Shooting Star. Shooting Star offered safety classes every time she bought a gun at Shooting Star. Further, we expect her to tell you that on the day in question, Justice Carbo jumped, hitting Drew Control's right arm, causing the gun to shift towards Justice Carbo. Lastly, we will call Jackie Staub, an expert in mechanics and gun safety. We expect them to tell you that Drew Control followed the industry's best practices when handling firearms. We expect them to tell you that Drew Control was fit to be entrusted and handle guns. We expect them to tell you that an appropriate background check was run on Justice Carbo, and he was sold a firearm appropriate to his level of experience. We expect them to tell you that it is unlikely that Drew Control flinched on the day in question, and that they personally examined the gun used by Drew Control, finding an overly sensitive trigger, which caused the gun to go off twice. The plaintiff will call 3 witnesses. They will call Justice Carbo. We expect Justice Carbo to tell you that on the day when they bought the firearm at Shooting Star ran 2 different background checks, and they agreed to give him training before taking the gun home. We expect them to admit to signing a release of liability and hold harmless agreement where they assume the risk in participating in a hazardous, dangerous activity on the shooting range. Further, we expect them to tell you that Drew Control glitched. However, we expect them to admit that they cannot state exactly how much Drew Control moved. They will call Ross Hernandez. Ross Hernandez really has nothing to bring to the table, as they weren't even there the date of the incident. They will call Dr. Morgan Judd, a hired gun, who based all of their opinions on plaintiff's testimony and disregarded what the eyewitnesses said. Members of the jury, accidents happen even with the best of preparation. Here, Drew Control was ready to teach the class, and Justice Carbo hit his right arm, causing the gun to drop. The gun malfunctioned, causing the gun to shoot twice. Accidents do happen. Thank you.
Counsel? I'll give the judges a moment to enter their score and comments. Judges, please let me know when you're ready. Justice Carbo, your counsel may present your case. As per the special instructions, you're required to call Justice Carbo the first witness. Are you ready to proceed?
Yes, Your Honor, the plaintiff is ready to call Justice Carbo to the stand.
You sit down in the witness stand and you conduct the sworn in.
And just for clarification, Your Honor, would you like us to ask permission to also approach you? When,
Yes.
may I proceed?
Yes.
Good afternoon. Could you tell the jury a little bit about yourself?
Good afternoon. My name is Justice Carvel. I currently live in West Pasquale, Imperial, and I've lived there all my life. I was born and raised in West Pasquale. My parents also lived in Imperial their entire lives as well. My father works as a mechanic and my mother works as a hairstylist. And while I had a pretty rough childhood, I worked very hard and eventually earned a full ride to Imperial State.
Do you like living in Imperial?
Absolutely, it's been my homeland for all my life, but recently it's gotten a little bit dangerous. My car has been broken into 3 times in the past few years alone, and I was mugged walking home one night. And so it's gotten to the point where I don't even feel safe in my own home anymore.
Did this make you want to buy a firearm?
Absolutely. I thought buying a firearm would be my best course of action to protect myself and get the peace of mind that I was looking for.
And where did you decide to buy this firearm from?
To be completely honest, at first, I was lost. I had never owned or operated a firearm before. But I did know that I wanted to go to a place where I could not only buy the firearm, but get instruction on how to safely handle it and store it as well. And through word of mouth and a couple Yelp reviews that I read, I eventually stumbled across Shooting Star Gun Club.
Now, did you contact anyone at Shooting Star Gun Club?
Sure. Before I decided to go in person, I contacted the owner, Skylar Coleman, over email.
And over email, did you make clear that to Skylar Coleman that you were a new gun user?
Absolutely, I laid out
Your
that.
Honor, best evidence.
Explain something.
Your Honor, the emails have been offered as exhibits, and the plaintiff is diving into the specifics of the emails without offering the exhibits and evidence.
Your Honor, for a best evidence objection, this is not best evidence. As what I'm doing, Your Honor, if I may proffer outside the presence of the jury, is I'm simply just laying some foundation to why Justice Cargo had to eventually go into Shooting Star, furthering how they got to the drink push.
Can you repeat the question you just asked?
I asked if they ever contacted Skylar.
Do you know where the best evidence rule is contained in this project?
That's true to the specifics of the case.
Because the best evidence rule,
Your Honor, if I may, I'm pretty sure it's stipulated too that within the empire, you can't object to best evidence.
Okay, well, I would need to see that to make a decision on that. What I'm gonna overrule you because in general, the best evidence rule, if you, it is a very tricky rule. It's one of the hardest rules. That you will learn eventually. It's quite a tricky rule. I don't think it applies in this case. It's possible other objections could apply, so that's something to consider.
Could you
Would you like-
repeat your question?
Yes, did you ever contact Skylar Coleman?
Yes, I contacted him initially over email just to lay out what I was looking for, stating that I wanted a gun for self-defense.
Your Honor, hearsay.
Can you repeat what the question was?
I asked if they ever contacted Skylar Coleman, Your Honor.
And then what did you respond?
Your Honor, the witness ones to the extent of what they said, which was an adequate statement.
I'm going to overrule for now, but re-raise it. Down that road, remember the witness needs to tell you about what they seen, not what they heard.
Yes, Your Honor. And now, did you ever go into Shooting Star Gun Club?
Yes, I decided to go in person first on May 15th. Spent personally an hour with Skylar Coleman discussing my options.
And after this, did you decide to buy a firearm from Shooting Star Gun Club?
I did at that point.
And what gun did you decide to buy?
I heard the recommendation of Coleman, which seemed a little quick, given that I hadn't really said much about how he was going to store the gun. But given his recommendation, I purchased the Glock 22.
Then were you able to pick up the firearm that day?
Not at that point. I had to come back 2 weeks later.
And when you came back 2 weeks later, did you take a safety course?
Well, I had mentioned that I wanted to take a safety course.
Your Honor, hearsay.
How so?
Your Honor, the witness testifying as to what they said that day is an adequate statement.
Your Honor, this isn't going for the truth of the matter asserted, but rather the effect on the listener as when this witness had to ask for the safety course when Skylar Coleman, it was then given to them leading into the safety course. So it was the effect on Skylar Coleman.
In that case, Your Honor, I'd like to ask for a limiting instruction that this not be considered for the truth of the matter, but simply for the effect on the listener as to Skylar Coleman.
I'll make sure to give the jury that. The overrule, but with the limiting instruction.
Yes, Your Honor. And did you have to ask for a safety course when you came back 2 weeks later?
Yes, I did have to ask for the safety course.
And who was teaching the safety course?
Drew Cantrell instructed the safety course.
What happened next?
Sure. So we walked over to the gun range, and at that point, we walked through some basic gun safety rules. Don't point the gun at someone unless you're shooting them. Always treat every gun like it's loaded, and keep your finger off the trigger unless you're shooting the gun. At that point, he instructed Nick Alred, who's also taking that course with me, and I to stand so we could get the best view of how he was discharging the weapon.
And where was Drew Cantrell standing during the safety course?
Drew Cantrell was standing right in stall 11 where we were having the push gun and where he would eventually shoot the target.
And where were you standing?
I was standing immediately to his right.
And where was Nick Allred standing?
Nick Allred was standing to my right, kind of in that alley between stall 11 and 12.
Would you recognize a copy of where you were standing in the gun range if I were to show it to you today?
I would.
Your Honor, at this time, may I approach opposing counsel with what has been pre-marked as Exhibit 2G?
You may.
And may I approach
You may.
with the copy?
Yes.
And now, what is this exhibit?
This is showing where we had the gun safety course, stall 11, and where myself, Drew Cantrell, and Nick Alred were standing.
Is it a fair and accurate depiction of where you were standing that day in the gun range?
Yes, it is.
Your Honor, at this time, the plaintiff moves to admit Exhibit 2G into evidence.
Any objections?
No objections, Your Honor.
Okay, it's admitted.
Your Honor, at this time, may I publish to the jury?
You may publish.
And now, what X was Drew Cantrell's?
Drew Cantrell was the blue X.
X was Nick Allred standing.
Nick Alred is the yellow X.
And where were you standing, Mr. Carbo?
I'm the red X.
And did Drew Cantrell instruct you to stand there?
Yes, per his instruction, that's where I was told to stand.
Did you feel at any time you were too close to Drew Cantrell?
Well, Drew Cantrell was the expert, and so I just trusted what he was telling me to do and followed his instruction.
And during the safety course, and I know this is hard to talk about, but How many shots did you hear that were fired?
I definitely heard 2 shots.
And what happened before the first shot was fired?
He kind of made a quick movement and his arm kind of flinched. And then suddenly the gun was pointed at my leg. Before that, he hit my left arm.
And after the second shot was fired, Mr. Carlo, what happened?
My leg went numb. I was in extreme, excruciating amount of pain. And at some point, paramedics must have been called, and honestly, my memory is a little bit of a blur of that point because of the amount of pain that I was in.
Mr. Carlo, would you have done anything differently?
The only thing I would have done differently is to never go to Shooting Star in the first place.
Thank you, Your Honor. I have nothing further.
Okay. Student Star, may begin cross-examination on the.
Yes, ma'am. May I proceed?
Yes.
I'd like to talk to you about how you heard of the Shooting Star. You heard of the Shooting Star through word of mouth, didn't you?
Yes,
And you also saw the Yuppie, correct?
I did read Young. Yes.
You saw that the Shooting Star had guns for sales, correct?
You repeat that?
Or you saw that the Shooting Star had guns for sales, correct?
Yes.
And that they also offered safety courses, correct?
Yes.
It sounded like the Shooting Star had everything you were looking for, correct?
Yes. Yes, that's correct.
Now I'd like to talk to you about your visit to the Shooting Star. You visited the Shooting Star on May 14th, correct?
That was my first visit to Shooting Star, yes.
And you met up with the owner, Skylar Coleman, correct?
Yes, at that point, I met with Skylar Coleman to discuss what I was looking for.
Exactly. You and Skylar Coleman spent over an hour talking, correct?
That is accurate, yes.
And in this hour, you two went over gun safe handling, correct?
Objection, Your Honor. As opposing counsel did object to this on my direct, and it was sustained, I asked that they refrain from talking about it on cross-examination, Your Honor.
What was the objection? Or what was the last question?
You and Skylar Coleman talked about, or you and Skylar Coleman spent an hour talking.
I thought, I did entertain that, I thought that I gave the lawyer his instructions.
Well, Your Honor, what the plaintiff is trying to show is that this is the truth of the matter asserted, what Justice Carbo did say, which is what the limiting instructed asked for.
Thoughts?
Your Honor, we are not offering this for the truth of the matter asserted, but simply for the effect on the listener. That after,
Can you ask Justice Carbo what Justice Carbo said?
or we were asking Justice Carbo as to what Skylar Coleman said.
And who's the party opponent?
Skylar Coleman is the representative of Shooting Star, but the opposing counsel does not call in today, Your Honor.
Can you repeat the question one more time?
You and Skylar Coleman went over safety, gun safety.
I mean, saying that you went over gun safety, so then that's very testified to be applicable by the court.
Your Honor, that's not the question that opposing counsel originally asked. They asked, what did you and Skylar Coleman discuss, Your Honor?
Okay, so I will sustain the objection, you can ask that.
Yes, Your Honor.
So you and Skylar Coleman went over gun safety, correct?
After I mentioned that I was interested in taking a gun safety course, we did discuss that they would be able to provide that to me, yes.
But Skylar Coleman also briefly went over gun safety storage, correct?
Could you rephrase that, please?
When Skylar Coleman was talking to you, they briefly went over gun storage, correct?
Well,
Gun safety.
That's after I mentioned that I was interested in learning how to safely store a gun. That is only when he went over gun safety storage.
But that's a yes, you did discuss about it.
Once again, yes, after I alluded to the fact that I'd never owned a gun and wanted to learn how to safely store a gun and also take the gun safety training course, yes.
And they also made a recommendation for firearms for self-defense purposes, correct?
Well, they very quickly recommended the Glock 22 handgun to me without really taking into account how I plan on storing the gun. But yes, he did recommend Glock 22.
And you both agree that you would come back in 2 weeks, correct?
We did agree that I would come back on May 28th, yes.
And on May 28th, they would have the firearm available for you, correct?
Yes, at that point of the firearm, I'd be able to pick it up.
And they would also have a safety course offered, correct?
Well, once again, I had been mentioned that I wanted to take that safety course. That was not directly offered to me.
But redirecting you back to my question, they did have the safety course, right?
Well, once again, after I had to ask to get that safety course, then it was offered to me at that point, but I had to ask for it. It
Objection,
wasn't-
Your Honor, the witness is being non-responsive. I'm going to instruct the following testimony.
Overrule the witness, you're allowed to ask questions and the witness is allowed to answer.
Yes, sir. But with the yes or no and the yes or no only, the safety course was offered on May 28th, correct?
No, I had to ask for it. It wasn't directly offered to me.
But with a yes or a no and a yes or no only, the safety course, you did take the safety course on May 28th, correct?
I did take it, yes.
And you took it right after you purchased a firearm, correct?
Once again, yes, after I had to ask for it.
And I'd like to talk to you about your second visit on May 28th. Skylar Coleman had you fill out the same government form you had previously, correct?
Yes, I had to recertify that form.
Exactly, and this was because you were actually purchasing the gun that day, correct?
That is correct.
And Skylar Coleman also ran a background check on you, correct?
He did run a background check on me, I assume, yes.
Now I'd like to talk to you about the safety course. The safety course was taught by Drew Cantrell, correct?
Drew Cantrell taught the safety course, yes.
And Drew Cantrell used the same firearm you purchased to teach the safety course, correct?
Yes, he did.
And he taught it to both you and Nagara, correct?
That is correct.
Now, Drew Cantrell told you and Nagara to treat every gun as if it were loaded, correct?
He did tell us that, yes, that was one of the gun safety rules of covenant.
And he demonstrated this by sliding out the ammo cartridge and showing them the bullets, correct?
Yes, like he did with all the rules, he gave a demonstration of how to follow.
Exactly, and the next rule he gave was to never point the gun towards anybody, correct?
Yes, unless you are shooting the gun at that person.
And he demonstrated this by pointing the gun towards the ground, correct?
Yes, down away from the gun.
Correct, away from both you and Nagara, correct?
Yes,
And in fact, you said that you believe they were handling the gun safely, correct?
at that time I did, and once again, in hindsight, I should not have trusted Drew Cantrell. But yes, at the time, I did think he was handling the gun safely.
And next, Cantrell demonstrated to you and Nagara how to shoot the fire, correct?
Correct, he walked us through how to handle the gun and shoot the gun, yes.
Exactly. He said to extend both of your arms outwards, correct?
He did, after we had placed our right hand around the butt of the gun, our left hand on the opposite side and interlocked those fingers, he told us that we should kind of put the gun out and away from our body. And use the notch on top to see where the bullet would go, yes.
And before he took a shot, Cantrell handed both you and Nagara goggles and earmuffs, correct?
Yes, he briefly put the gun down and handed us goggles and earmuffs before he shot the weapon.
And this is another form of safety precaution, correct?
Objection, Your Honor, lack of personal knowledge, if I may.
You may,
As Mr. Carbo has testified on direct and cross, he is a novice gun user. He's never held a gun before. He's taking this course because he knows nothing about gun safety. And opposing counsel is asking my witness if wearing eye protection and earmuffs are proper safety, which my witness knows nothing about as a novice gun user.
Your Honor, if I may respond, the witness is allowed to give their opinion as this is their witness opinion rationally based on their perceptions of the events. They were present during the safety course, and Cantrell, the safety instructor, handed both him and Nagara goggles and earmuffs as a part of the precaution.
I think that the jury is allowed to hear what Carbo subjectively believes is safe or not. I think obviously there, the jury is not going to clearly reflect that only the expert is allowed to make expert opinion on anything unless kind of establish sort of the higher level theory. So
Yes, Your Honor.
Could you restate the question?
Goggles and earmuffs are a form of safety precaution, correct?
Yes, I believe they were a form of safety precautions as they were given to me by the gun safety instructor.
Now I'd like to talk to you about the actual shooting. You say Cantrell flinched prior before he shot, correct?
Yes, I did say that.
But you can't say exactly how much he moved, correct?
Well, I can tell you that he moved enough to have the gun now pointing at my leg.
But you can't say exactly to what specifics how much he moved, correct?
Once again, I can't get it down to the exact inches, but I can tell you that it was enough to point at my leg and subsequently shoot my leg.
And you also didn't see where the bullets went, correct?
No, because I was instructed to focus on how he was handling the weapon, and so that's where my focus was.
And with a yes or no and a yes or no only, you are a complete gun novice, correct?
Yes,
And Cantrell is the firearm safety instructor, correct?
yes, he was the firearm safety instructor. Firearm safety instructor, yes.
Your Honor, at this time, may I approach the opposing counsel to demonstrate a copy of exhibit 17.
You may.
Let the record reflect that I have tendered a copy of exhibit 7 to opposing counsel. A handle has been marked as exhibit 7. Can you identify this?
Yes, this is the liability form I signed prior to entering the gun range.
And is it a true and correct copy of the liability waiver you signed?
Yes, it is.
And has it been changed and altered in any way?
No,
And does it accurately and fairly depict the contents of the waiver you signed?
yes.
Your Honor, at this time, I would like to move exhibit 7 into evidence.
Yes, Your Honor, objection to relevance, if I may explain, due to the case law of McAndrew v. Guard Skydiving Adventures, any signed liability waiver or release form will not serve to combat a negligence claim and therefore is irrelevant in today's trial, Your Honor.
Response?
Yes, Your Honor, under the same case law of McAndrew v. Guard Skydiving Adventures, it also states that a waiver is relevant towards a case if it goes to show that the plaintiff had particular knowledge or notice of a particular fact. And in this case, we're using it to show that plaintiff Justice Carville had the knowledge of the risks and hazards involved in participating in the gun.
Reply.
Your Honor, as McAndrew does state that a signed liability waiver a release form doesn't combat a negligence claim, it is therefore irrelevant in today's trial.
Overruled, because as I read this, it says that it will this state will not comprehensively defeat it, but it also says, as the defense counsel points out, the existence of the waiver may still be relevant to demonstrate that the plaintiff had notice or knowledge of a particular fact. And it does not raise any assumptions regarding the viability of any affirmative defense at the trial. So, overruled.
Yes, Your Honor.
Your Honor, at this time, may I put a demonstrative of exhibit 7?
Do you have any other reference to the exhibit?
Yes, Your Honor, I'm definitely hearsay.
Please explain.
Your Honor, this is an out-of-court statement being offered for the truth of the matter asserted that the contents of this waiver are what they say they are and that Justice Carville is. So it is an out-of-court statement.
Are you challenging the validity of the signature?
No, I'm not challenging the validity of the signature, Your Honor. I'm saying that this is an out-of-court statement and opposing counsel will be using it for the truth of the matter asserted and therefore is hearsay.
Your Honor, may I confer with my counsel?
You may.
Your Honor, may I respond? Your Honor, under the case law of the United States versus tyranny, it is mentioned that hearsay is exceptional. We are offering a legal claim towards, or the legal claim towards a exhibit or a statement.
Reply.
Your Honor, US v. Tyranny does state that says that a verbal act is a statement offered to establish something of an independent legal significance of effect, which this is not a verbal, this is physically signed, Your Honor. So this is still hearsay.
Well, okay, let's read tyranny together. Paragraph. It says a verbal act is a statement offered to establish something of independent legal significance or effect, rather than the truth of the matter asserted. Statements which by their existence impose legal responsibilities and grant legal rights upon the parties thereto are verbal acts and are therefore admissible as non-hearsay. For example, a contract executed by both parties would be admissible to establish the terms thereof. Do you have any response to that? Because when I read it, it does seem to imply that it turns a contract into a verbal act in a sense.
Yes, Your Honor.
Do you have any other objections?
No, Your Honor.
Okay. Then all of that being said, the exhibit is admitted.
And may I put up a demonstrative of this?
You may put up.
Now, Mr. Carbo, you were fully aware of all the risks and hazards that were involved in participating in the gun range, correct?
Yes,
As mentioned in the second paragraph, correct?
yes,
And you also took full responsibility for any accidents that were to occur, correct?
yes,
And this is your signature down at the bottom, correct?
that is my signature, yes.
Your Honor, at this time, may we publish Exhibit 7 to the jury?
Any objections?
No, Your Honor.
Okay. It's done. in public hearings.
Yes, Your Honor. Thank you, Your Honor. I have no further questions. I guess.
Okay, would you like the monitor to remain up?
Yes, Your Honor.
He would like it to remain up?
Oh, could I do a brief redirect, Your Honor,
Yes,
with the demonstrative on?
whichever way.
No, may I proceed?
You may.
Mr. Carbo, are you a novice gun user?
Absolutely,
Have you ever signed a gun waiver before?
never before.
Did you understand most of the language used within this waiver?
I mean, it's a lot of legal terminology, so, I mean, as a novice to guns, it's a little bit confusing.
Did Sarah Coleman ever explain to you what this waiver meant?
No, no.
Thank you, Your Honor. I have nothing further.
Any recall?
No recross, Your Honor.
Okay. So, Margo, you are dismissed and you are no longer under constructive order to tell the truth. And because you have the option of leaving the courtroom.
Thank you, Your Honor.
Oh, Your Honor, I just asked if opposing counsel is now done using this demonstrative, as I've already conducted my recross and redirect. Could they please take it down, Your Honor?
Yes, it's in the demonstrative. In general, after when you get past witnesses, up for the after the demonstrative stays up, and once the witness is done, but the hard demonstrative. Okay, we are going to take a couple of very brief seconds to score. Justice Carbo, you may call your next witness.
Yes, Your Honor, the plaintiff calls Ross Hernandez. However, before we proceed, we ask for a brief time check.
Time check.
44 minutes and 17 seconds.
Okay, the constructively sworn in.
Your Honor, may I proceed?
You may.
Good afternoon, Mr. Hernandez. Please introduce yourself to the jury.
Good afternoon. My name is Ross Hernandez. I'm proudly born and raised in the West Pascal Imperial.
You still live in here now?
Yes, I do.
Where do you work?
I own a chess tutoring business.
Why do you just do business?
After I finished high school, I had a love for chess, so I did not go to college. Instead, I opened a chess tutoring business. I guess that was the right decision because I was happy as a promoted pawn.
Mr. Hernandez, where is your business located?
It's located in the Imperial on Strip Mall.
Since your business is located in Imperial Strip Mall, are you familiar with a company called Shooting Star?
Yes, of course. They were my neighbors in the mall, just as close as 2 pawns on a chessboard.
Now, what is Shooting Star?
The Shooting Star is a gun club that has a gun range and a bar. You can go there to learn how to shoot.
Please explain.
To Shooting Star under the bar.
Your Honor, relevance 401 is any fact has a tendency to make a fact of the case more or less probable, but this is simply laying foundation for how Mr. Hernandez is frequently at Shooting Star, because he's frequently at the bar Shooting Star with Skylar Coleman, therefore is relevant to this case.
Well, it's not relevant to the case because it's not really into the negligent side of things.
Overruled, it's any tendency, so this is kind of establishing why it's there as we said.
Yes. Would you like me to repeat the question, Mr. Sanders?
Yes, please.
What is shooting star?
Shooting Star is a gun club that has a gun range and a bar. You can go to learn how to shoot there or just eat. I go there almost every single day.
Do you know the owner of Shooting Star?
Yes, I do.
Who is he?
The owner is my friend, Skylar Coleman.
What experiences have you had with Skylar Pullman?
Well, I met Coleman at the bar. We talked about things that go on in the strip mall. He also helped me to make profit from my chess business.
How has Coleman specifically helped you, Mr. Sanders?
Well, there was one instance where I needed to renew my lease for my business, and I asked Coleman to help. So Coleman did a big move and delivered a stunning checkmate to land me a 10-year deal.
Now, let's talk about the employees at Shooting Star. Are you familiar with any of the employees?
Yes, most of them, in fact. I know all the instructors. I see them about giving lessons and handling guns.
Do you know the instructor, Drew Cantrell?
Yes, I do.
Who is Drew Cantrell?
Drew Cantrell as an employee at Shooting Star.
Have you ever seen Cantrell shoot?
Yes, I have. They missed targets on multiple occasions.
Objection, Your Honor. Improper physical evidence,
How's that group?
because there is including evidence to show that they shot like this often and on the day in question.
Your Honor, historical character evidence is any character trait about the defendant or representative of the defendant. However, there are no character traits being offered, and before trial, we gave opposing counsel a character evidence form, which does state that we'll be offering the recklessness, carelessness, and the shooting traits of Cantrell. Therefore, it is not character evidence in today's case.
So you would say because we've done, signed the character evidence thing, then you're allowed to do character.
Yes, Your Honor, but even so, we're not offering any character traits in this statement. And opposing counsel, not to mention, has signed that form as well.
Reply?
May I?
Yes, me.
Your Honor, just because we signed that paper, it does not mean that we are not restricted to objecting to improper character
Can I
evidence.
see the waiver?
Yes, Your Honor.
Because I'm pretty sure the waiver waived the character evidence objection, but I also don't think, I'm gonna overrule it though, because this is the character evidence, whether he's misshot before doesn't really count as character evidence. That would be more like, character evidence is more like if you see someone, you know, because he committed murder before, he's been hurt. So overrule.
Yes, Your Honor. Mr. Hernandez, would you like me to re-ask the question?
Yes, please.
How has Cantrell shot?
Not very good. That reflects their chess
Objection,
ability.
Your Honor.
Yes.
Improper expert opinion. As to not very good.
Overruled, I think the jury can understand that this is a lay person who sort of seems someone shoot. This isn't a, you know, qualified gun tester slash, so overruled, but the jury will be instructed, of course, only the expert is here. That's coming.
Yes, Your Honor. Mr. Hernandez, would you like me to re-ask the question?
Yes, please.
Now, based on what you observed, how has Cantrell shot?
They have missed targets on countless occasions.
Have you ever seen any incidents with Cantrell?
Yes, I have. I have witnessed two, in fact. One in May 2021 and the other in November 2021.
Objection, Your Honor.
Yes.
Relevant.
Your Honor, 401, as you previously stated, is,
What was the question?
the question was, have you witnessed any incidents with Cantrell?
Overruled,
Your Honor.
overruled. But you may re-raise any of your objections to the question.
Yes, Your Honor.
Mr. Hernandez, would you like me to re-ask the question?
Yes, please.
Have you ever witnessed any incidents with Cantrell?
I have two. One in May 2021 and the other in November 2021.
Well, let's take these one by one. First, starting with the May 2020 incident. What happened during this incident?
Objection, Your Honor. Relevant.
How is that not relevant? If they have if one of their claims is negligent firing based on.
Your Honor, may I ask for the jury to be constructively discharged.
Yeah, the construction.
Well, Your Honor, just because Drew Control was aiming the gun towards the shop floor on May 21st does not make Drew Control a negligent hire. It
Well, I
was
think,
simply a mistake where nobody was hurt, and under what we know, we still negligent hiring requires that the employer's failure to investigate, screen, or supervise its influence ultimately caused the plaintiff's injury. This incident did not proximately cause plaintiff's injury.
overruled, it's relevant towards their negligent hire argument, at least a little bit, so it's not irrelevant.
Yes, Your Honor. Mr. Hernandez, would you like me to re-ask the question?
Yes, please.
Can you please describe what happened in May of 2021?
I was at Shooting Star that day, specifically the Shooter Mac Taverns, and there was a huge ruckus behind me. So I turned around and I saw Drew Cantrell and another employee in an aggressive argument. Cantrell had a gun on their side.
You just mentioned Cantrell had a gun on her side. Did the situation escalate at all?
Yes, it did. All of a sudden, Drew Cantrell pointed the gun at another employee.
Was Coleman at this incident?
No, not all of it. However, he barged in saying, "We don't do that here."
How did Coleman seem to react in your experience?
Coleman seemed to be angry. He then went back into his office and came back with a notepad. He came up to me and asked me questions while taking notes.
After this incident, Mr. Hernandez, was Drew Cantrell still employed at Shooting Star?
Yes, he was. In fact, I played chess with him a week later.
Now, let's talk about that November incident you mentioned. Where were you during this incident?
I was at Shooting Star that day.
Did you see what happened in November 2021?
No, I didn't, but I heard absolutely everything.
Well, can you describe to the jury what you heard?
Yes, so I walked over to where Coleman usually is, and I heard Coleman's voice yelling at Drew Cantrell a few times.
Why was Coleman?
Coleman was yelling because Drew Cantrell had brought a loaded gun into the gun shop.
After this incident, was Drew Cantrell still employed at Shooting Star?
Yes, he was. I saw him walking out of Shooting Star after I finished work.
Thank you, Mr. Hernandez, and thank you, Your Honor. Nothing further.
Okay, cross-examination time?
Good afternoon, everyone. Afternoon. You really, I'd like to talk to you about Cantrell. You really can't stand Drew Cantrell, can you?
Yeah, he's not my favorite person. I don't have to like everybody.
Right, and you try your best to avoid Drew Cantrell.
Yes, I do.
And you've never interacted with Drew Cantrell as a firearm safety instructor, have you?
No, I haven't.
Objection, Your Honor, relevance.
Can you repeat the question, Colin?
You've never interacted with Drew Cantrell as a firearm safety instructor.
It's actually quite a hard case overall.
Yes, Your Honor.
Is that a yes to my question?
Can you please repeat the question?
You've never interacted with Drew Cantrell as a firearm safety instructor.
No, I haven't.
So therefore you have no personal knowledge of how Drew Control runs or conducts a firearm safety class.
No, I don't.
Now I'd like to talk about the incident in May of 2021. You were chatting with a friend in the shop before heading over to the cafe that day.
Correct.
And you weren't really paying attention to what else was happening in the shop.
Not until there was something behind me, and then I started paying attention to how Drew Cantrell
Right,
pointed the
so
gun.
that's yes to the question. And you heard Drew Control tell Skylar Pullman that the gun wasn't loaded.
Objection, Your Honor, hearsay.
Your Honor, can I respond?
No.
We're not offering this for the truth of the matter, so that before the effect on the listener that Skylar Coleman heard Drew Control say that the gun wasn't loaded and still reprimanded.
Your Honor, 801 hearsay is any out-of-court statement being offered for truth of the matter asserted. And we do believe that this is being offered for the truth of the matter asserted that there was no bullets in that gun. And that's what opposing counsel is offering us in today's case.
Fine.
I stand by my response.
Okay, I'm going to overrule and make sure to put the limiting instruction.
Yes, Your Honor.
So that's a yes to my question.
Can you please repeat the question?
You did, however, clearly hear Drew Control say that the gun wasn't loaded to Skylar Coleman.
Yes, however, Coleman said it didn't matter.
Now let's talk about the incident in November of 2021. Let me be clear, you didn't actually see what happened in November of 2021.
No, I didn't, but I understood absolutely everything.
And all you did was hear Skylar Coleman reprimanding your control.
Yes,
And now I'd like to talk about the incident on May 28th, 2022, where Justice Carver was shot dead. You weren't actually there at the shop the day of the incident.
no, I wasn't there. I had a really important chess tournament I had to be at.
Right. And so you have no personal knowledge of what happened when the firearm was shot?
No, I just read about it.
No further questions, Your Honor.
Okay, any regret?
Yes, Your Honor.
Okay, counsel, you may please move the
May I proceed?
You may.
Did you hear what happens in November 2021?
Yes, I did.
What did you hear?
I heard the fact that Coleman was yelling at Drew for him bringing a loaded gun into the gun shop floor.
Thank you, Mr. Simmons, and thank you, Your Honor.
Any regret?
No regret, Your Honor.
Okay, your defendant no longer be sworn in. Give us a second to get our sworn in, and then we will review. Are you guys ready?
I'll start you there.
Okay, please may call your next witness.
Yes, Your Honor, at this time, the plaintiff calls Dr. Morgan Judd to the stand.
Dr. Kirby, or please sworn in.
Your Honor, may I proceed?
You may.
Good afternoon. Would you please introduce yourself to the jury?
Good afternoon. My name is Dr. Morgan Judd.
And Dr. Judd, just before we get into why you're here today, why don't you tell the jury a bit about yourself?
Of course, I'm currently an associate professor at the Center for Gun Violence Prevention at Imperial State University.
And what certifications do you have to be an associate professor?
Currently, I have my master's, I have a PhD in public policy, and I also have a firearm safety certificate.
And do you have any firearm safety training as well?
Yes, before I actually became a professor, I worked at the Bureau of Alcohol, Firearms and Explosives and Tobacco Unit before I became a professor.
Dr. Judd, now that the jury knows a bit about you, why don't you get into why you are here to testify today?
I was retained by the plaintiff to testify and to analyze some of the best guidelines and gun safety practices in relation to Shooting Star's actions in today's case.
What materials did you review while doing it?
I reviewed affidavits, exhibits, eyewitness testimonies of the shooting that occurred. And while analyzing all these different parts of the case, I also used some of the 5 basic gun safety principles.
Was there any evidence that you disregarded?
No, I looked at everything in today's case that was provided to me.
Now, you just mentioned, basic firearm safety rules, so could you expand on that?
Yes, there are 5 basic firearm safety principles when it comes to safely handling and operating a weapon.
Could you please tell the jury what those 5 basic rules are?
Sure, they're very simple. The first is to always keep your weapon unloaded unless you're firing it. Number 2 is to never point a weapon at another person unless you intend to shoot them. Number 3 is to always keep the safety engaged unless when firing. Number 4 is to always know your target and beyond. And number 5 is to never pull the trigger except for when firing.
So how exactly did you relate these 5 basic rules of gun safety to your analysis today?
Could you repeat the question?
Yes, so how did you relate these principles to your analysis in today's case?
When I was looking at all the evidence in today's case, I used these 5 basic principles to analyze if Shooting Star had any violations and specifically Drew Cantrell, and I found that they did.
Well, and what violations did they have?
I found that in May of 2021, there were 2 incidents in total, but I found that in May of 2021, one of the 5 basic gun safety principles was violated.
And what violation occurred?
The first basic rule, or the second basic rule of gun safety was violated in this instance. This is when Mr. Cantrell pointed a weapon at another person, and this was a clear violation of rule number 2.
And you just mentioned that there were 2 violations in total. Can you expand on the second violation?
Yes, I found that the second violation occurred in August of 2021, which was a clear violation of the first basic principle of gun safety, which is to always keep your weapon unloaded and you're firing it when Mr. Cantrell was found leaving a loaded gun on the shop floor.
And Dr. Judd, in your opinion, should these 2 violations have been a concern to Shooting Star?
Absolutely. When I was reading them, they were a huge concern to me and they should have been a huge concern to Shooting Star.
Dr. Judd, why is it?
When it comes to gun safety, these 5 basic principles are the foundation of safely operating and using a firearm. And Mr. Cantrell has a firearm safety certificate. The fact that he can't even follow these 5 basic rules is a huge concern.
You just mentioned that Drew Cantrell has a certification. Are you aware of if he had that certification when he was hired?
I am aware, and Mr. Cantrell was hired without any certifications when he was handling weapons.
So following these 2 concerning violations, was Mr. Cantrell let go from his position as Shooting Star?
No, following these violations, Mr. Cantrell was actually promoted.
Dr. Judd, what position was Drew Cantrell promoted to?
He was promoted to a firearm safety instructor.
What does a firearm safety instructor actually do?
Well, a firearm safety instructor teaches firearm safety. They teach novice gun users how to handle and safely operate weapons.
Now, did you find that before the promotion, Shooting Star ever re-interviewed Drew Cantrell?
They did not.
Did you find that before the promotion, to your knowledge, Shooting Star reevaluated Drew Cantrell's fitness as an employee?
And no, there was no reevaluation.
Did you find that before the promotion, Shooting Star made Drew Cantrell undergo further basic gun safety training?
No evidence suggests there was any further training following these violations.
No. I would like to discuss what happened after that promotion, specifically May 28th, 2022. Was Drew Cantrell in the range that day?
Yes, Drew Cantrell was assigned to teach the safety course that day with 2 novice gun users, Nick Allred and Justice Carlo.
Did you find that during that safety course, any violations occurred?
Yes, I found that not only were the 5 principles of gun safety that I mentioned earlier were violated, I also noticed that some of Shooting Star's own gun range rules were also violated.
Would you recognize those gun rules if I were to show them to you today?
Yes, I would.
Your Honor, at this time, may I have permission to approach the closing counsel what has been pre-marked for today?
Okay.
The record reflects that I will approach him with the same. Would Your Honor like a copy?
Yes, please.
So Dr. Judd, what is this exhibit?
These are the gun range safety rules posted by Shooting Star.
And how do you recognize them?
I reviewed them in my analysis of today's case.
And have they been changed or altered in any way since the last time you viewed them?
No, they have not.
Your Honor, at this time, the plaintiff moves to admit Exhibit 8 in evidence.
Any objection?
No objections, Your Honor.
Okay, let's move to evidence.
Your Honor, permission to publish to the jury?
May publish.
Now, Dr. Judd, could you please point out for the jury exactly which one of these rules was violated during that training course on May 28th?
Yes, I found that multiple were violated. If you'd like to follow along with me, the first one Mr. Cantrell violated was only point at it if you want it destroyed. He also violated the mind the trigger rule, be safe. If it's loaded, leave it on the line, protect yourself, check your weapon, and know your target and beyond.
So, Dr. Judd, how many rules were violated?
7 out of the 9 company rules were violated on May 28th alone during the safety training course.
Well, let's just focus on a couple of the ones you find to be most important. Which rules do you find to be the most damaging in today's case?
I found that the check your weapon and know your target and beyond rules were the most important rules that were violated in today's case. I found that Mr. Cantrell did not check his weapon before firing it, and therefore if there were any malfunction, it was not found before he fired his weapon. And the know your target and beyond rule, Mr. Cantrell was extremely close to Mr. Carbo in today's case, and I found that it contributed greatly to Justice Carbo's injury.
Dr. Judd, can you please read aloud for the jury the very last line in this exhibit?
Yes, failure to abide by the above rules may result in removal from the facility and denial of future shooting privileges.
Dr. Judd, does Drew Cantrell still work at Shooting Star today?
Yes, they do. In fact, they still teach safety training courses.
So, Dr. Judd, what is your expert opinion in today's case based on your analysis?
Based on my analysis, I found that Mr. Cantrell was irresponsible with firearms. He continually violated, and on May 28th alone, violated 7 out of the 9 company rules posted by Shooting Star. And even if accidents happen, Shooting Star wasn't prepared for what happened to Justice Carbo.
Thank you, Dr. Judd. Thank you.
Cross-examination.
Yes, Your Honor.
You may proceed when ready.
You were retained by attorneys for Justice Carbo, correct?
That's correct.
And you are charging $400 per hour.
Yes, it's the standard rate.
And for being called to trial today, you billed a special rate of $600 per hour, correct?
Yes, that's correct.
Plus a flat fee of $6,000.
Yes, that's correct.
So you're charging $6,000 only for testifying for 10 minutes?
It's the standard industry rate, and I bring a lot to the table.
You only spent 36 hours on this case, correct?
Yes, this included analyzing exhibits, affidavits, and eyewitness testimonies of the shooting.
Correct, but you didn't interview any of the witnesses, did you?
No, that's not my job.
You didn't read all the witnesses' statements?
I read the ones that were important and were eyewitness testimonies of what happened in today's case.
But you didn't read all of the witnesses' statements, correct?
That's correct.
You didn't read the expert report of Jackie Staub.
No, I was not provided with that information.
Your niece was shot when shooting broke out at a Liberty party, correct?
Yes, it was a very tragic incident.
And in this experience and your grief of loss of a close family member changed your view in gun violence, correct?
Yes, I've worked at the Bureau for quite a long time, so I'd seen lots of gun violence, but this just reassured that gun violence is horrible.
And your life calling is ending gun violence?
Yes, of course.
And big verdicts against retailers would stop gun violence, wouldn't it?
Could you repeat the question?
And big verdicts against retailers would stop gun violence.
Yes.
Now I'd like to talk to you about the best practices for firearm safety. You'll agree with me that guns can be used safely by trained professionals, correct?
Yes, if they're well prepared and actually well trained.
And you said that there are several safety protocols?
At Shooting Star, yes, but they weren't sufficient in today's case to help Justice Carbo from not getting injured.
That is a yes, correct?
Yes.
One of them being always keep firearms unloaded except when in use,
Yes, it was a rule, not exactly a safety protocol.
but it is a safety protocol.
I would say it's more of a rule. It's not something that prevents violence, because in today's case, Mr. Cantrell violated that rule.
So you do agree that it is a safety rule?
Yes, a rule.
And isn't it true that Cantrell went to the shop to unload his gun right after he was done using it?
Are you talking about the August incident
No, this is the May incident.
or the May incident? Yes.
Coleman told Cantrell to treat every gun as if it was loaded, correct?
That's correct, and Mr. Cantrell did not.
The shop wasn't crowded or anything,
That's correct.
so no one was actually hurt.
That's correct. No one was injured in this case, but on May 28th, someone was.
And Coleman had a stern talk with Cantrell about this incident, correct?
That's correct.
You said that the second incident of Drew Cantrell's was in August of 2021, correct?
Yes, that's correct.
But it actually happened in November of 2021.
The second incident occurred in November. The first incident occurred in August. Are you referring to the first or the second?
The first incident happened in May of 2021.
Yes,
The second incident happened in November of 2021.
yes, this
You
was where
said
Mr.
in your direct
Cantrell.
examination that the second incident happened in August of 2021.
I must have misspoke. It was November of 2021.
Now I would like to talk to you about another safety protocol. Never point a gun at another person unless you intend to shoot that person.
Yes, Mr. Cantrell.
You say
violated this
Cantrell pointed a gun at another person.
multiple times, yes.
But you'll agree with me that Drew Cantrell says he was just inspecting a gun.
In this instance, yes, but on May 28th, he shot the weapon at Mrs. Harbaugh.
But in this case, you do agree with me that Drew Cantrell did say he was just inspecting the gun.
Still, he held it at another employee.
Cantrell said that he didn't point at another person.
That's what Cantrell states, but many other witnesses affidavits say that he pointed it directly at another person.
And that Cantrell says that he was just pointing at the shop floor.
Yes, as I stated.
Now I would like to talk to you about another safety protocol. Your next protocol is never pull the trigger unless when firing, correct?
That's correct.
You will agree with me that Cantrell said he only pulled the trigger once.
Yes, but I found that a malfunction was very unlikely in today's case, and he most likely pulled the trigger twice.
But you do agree with me that that is what Drew Cantrell said, that he only pulled the trigger once.
Yes.
He said he didn't pull the trigger that shot into Carbow's leg.
Yes, but other testimonies say otherwise.
Now I'd like to talk to you about safety measures. It's your opinion that anyone operating a firearm should use safety equipment, correct?
Yes, that's correct.
Which includes ear and eye protection.
Yes, that's correct.
So you do not dispute that Cantrell gave Justice Carbo proper ear and eye protection.
After entering the range, which is a clear violation. The rule states that you should have it on at all times in the gun range.
Redirecting you back to my question. You do not dispute that Cantrell did give Justice Carbo proper ear and eye protection.
After the rule, yes.
But he did give them the safety equipment, correct?
I said yes.
Now let's talk to you about the recoil in the gun. You agree with me that the brand, age, and the prior use of guns can cause recoil to the gun, correct?
Objection, Your Honor, improper expert opinion, as this expert is not an expert in firearm mechanics and does not know the operations of a firearm in detail.
Response?
Your Honor, although this is an expert in gun safety, it was said in their statement that the brand, age, and the prior use of guns can cause recoil to the gun.
Can you repeat your question to me again?
Do you agree with me that the brand, age, and the prior use of guns can cause recoil to the gun?
Overruled for now, you can raise it if it goes far, if this is within the scope of the report.
Yes, sir.
Yes, they can all affect the recoil.
So no two guns feel the same?
No, but two guns of the same model will have relatively the same recoil. That's why a trained professional should be able to handle certain recoils.
Even the choice of ammunition can cause further variables into the shooting experience, correct?
That's correct.
And they could change the strength of the recoil.
That's also correct.
But you know, Cantrell said that the recoil was much more violent than any other handgun he had ever handled before.
Objection, Your Honor, hearsay.
Response?
Your Honor, under Rule 703, experts can rely on hearsay.
They can, they really shouldn't be kind of conduit to it, reply.
Once again, Your Honor, opposing counsel is using statements that are outside of the court and are offering them for the truth of the matter asserted and are inadmissible.
Well, Your Honor, under Rule 705, I can cross the witness under underlying facts based of their opinion.
What was your question again?
You know, Cantrell said that the recoil was much more violent than any other handgun he had ever.
Your Honor, may I be heard? This witness's opinion in today's case had nothing to do with the recoil of the firearm, and therefore that does not apply.
May I ask the closing counsel to clarify?
Yes, they just testified that they are allowed to ask this witness about things related to the underlying opinion. However, nothing in this witness's opinion in today's case consisted of anything regarding the firearm mechanics or the recoil in today's case, which is what opposing counsel is offering it for, is asking about. And therefore, this is still an out of court statement being offered for the truth of the matter estimate.
Well, Your Honor, I merely just crossing their opinion based on their underlying facts, based on their opinion.
Overruled now, but we raised this at December 15,
Yes, sir.
Yes, Mr. Cantrell did state that the recoil is stronger than normal.
And Cantrell also said that Turbo jumped after the first shot was fired, correct?
Yes, but other testimonies refute that idea.
Cantrell said that this caused Carbo's left arm to hit Drew Cantrell's right arm.
Yes, that's good.
Cantrell says that Carbo knocked his arm so hard that the gun fell out of his hands, correct?
That's what Cantrell states, yes.
And that's when the second shot was fired.
Yes, but other testimonies state that he pulled the second.
But you know that Drew Cantrell said that he didn't flinch
That's what Drew Cantrell says, yes.
and that he didn't pull the trigger a second time.
Again, that's what Drew Cantrell says.
And that the only people that said that saw Drew Cantrell flinch were Carbo and Albert.
Yes, they were the only other two people by Drew Cantrell.
And as stated before, they are both gun novices, correct?
Yes, but they can notice a flinch.
Since none of them have any experience with handguns,
That's correct.
but they can't tell the difference between a flinch and a natural recoil, can they?
Objection, Your Honor, speculation. This question calls for speculation as opposing counsel is asking this witness to testify to the knowledge of Nick Alred and what he believes about flinches, and this witness has no knowledge of that.
Response?
Yeah, I'll move on.
Okay, same.
Yes,
Cantrell was proficient enough to earn a license as a firearm safety instructor, correct?
Could you say that again? I'm sorry.
Cantrell was proficient enough to earn a license as a firearm safety instructor.
That's correct.
Do you agree with me that Shooting Star was best equipped to make a determination to Cantrell's fitness?
That's correct.
Shooting Star obviously decided that Cantrell was fit.
Yes, although the previous violations.
No further questions, Your Honor.
Any redirect?
Yes, Your Honor.
Okay, you may receive and ready.
Well, Dr. Judd, did the unfortunate passing of your niece to gun violence in any way affect your conclusion in today's case?
No, while it did affect me, I think my opinion is completely unbiased in my job.
Dr. Judd, does the fact that no one was hurt in the instances prior to what happened on May 28th mean that rules were still not violated?
No, I found that despite no one being hurt in the first two instances, they were huge violations that should have been a huge concern to Shooting Star, yet he still works there.
In your opinion, would following proper safety protocols have reduced the likelihood that Justice Carbo was shot in today's case?
Yes. I found that Mr. Cantrell violated multiple safety rules. All of these contributed to Justice Carbo's injury.
Exactly what has to be done in order to obtain the certification that Drew Cantrell has?
To become certified in gun safety, all you have to do is send in some paperwork.
So is it possible that someone could have a safety certification and still not be sufficiently trained in firearm safety?
Yes, that's apparent in Mr. Cantrell's actions.
Thank you, Your Honor.
Any request?
No request, Your Honor.
Okay, you're dismissed. Now that concludes the plaintiff's case in chief. We will take a no more than 5-minute break unless either side has an objection. I see the case start to talk for 5 minutes, and I will note because we are a little bit slow, we can 5 minutes only, so you have 5 minutes if you want to use that. 340. We all lost that. We all lost our. No, 341 is when the trial started. Yeah. You take down.
I'm a guest.
Here we go, everybody. 3, 2, 1.
3, 2,
Good job. 3, 2, 1. Okay. All right.
Are you like a professional photographer?
Keep them. Keep them down. All right, here we go. Everybody right here. This here. Y'all ready? All right, here we go. 3, 2, 1. 3, 2, 1. All right, let's have fun. Let's have fun. Everybody's open right now. I love it. All right, here we go. 3, 2, 1. Awesome. Yes. Taking the picture, y'all at home. Here we go.
Oh, yeah. Oh, yeah.
3, 2, 1.
Let's go. Thanks, Elliot.
Okay. So everyone, 5 minutes past, so we're going to restart the competition. Our gun club, we have a case. As you heard in start construction, you are required to call three to tell it the first witness. Are you ready to speak? Cantrell, you may approach. And if you can cut the police sworn in and speak.
Yes, sir.
Please state your name to the jury.
Well, good afternoon. My name is Drew Cantrell. That's spelled Cantrell.
Where do you work?
I currently work at Shooting Star Gun Club. I'm a firearm safety instructor there.
And how many years have you worked at Shooting Star?
For over 3 years.
What is your current position at Shooting Star?
Well, like I said, I'm currently a firearm safety instructor.
And how long have you taught? Oh, sorry. What are your certifications?
Currently, I have 2 certifications, a firearm safety certificate, which required me to go to training for, well, firearm safety, and then also a firearm instructor certificate, which actually gives me the ability to teach these firearm safety classes.
And how long have you been teaching firearm safety class?
Now would be for over 2 years.
And what experience did you have handling guns prior to Shooting Star?
Well, I've been using guns my whole life. It first started when I was a kid. I went hunting with my dad over time, and after that, I just fell in love with guns. It's been my hobby ever since.
Your Honor, at this time, we offer due control as an expert in firearm safety.
Your Honor, the proper certifications and foundations has not been laid to Drew Cantrell's experience as a firearm safety instructor. Most of the time, experts have published works more experience than just 2 years in teaching firearm safety. Therefore, he cannot be tendered as an expert in firearm safety.
Your Honor, I believe I've laid the foundation with the questions prior. And under Rule 702, an expert requires experience, knowledge, skill, training, or education. Drew Cantrell only needs 1 of these, and Drew Cantrell has 4 of these, as he has 2 certifications, 1 in firearm safety and 1 in firearm safety instruction, and he's been teaching classes for 2 years in firearm safety.
Counsel, did you list Drew Cantrell as a potential expert witness?
No, Your Honor.
Your Honor, along with them not listing them as a potential expert witness, firearm safety qualification certificate's like a driver's license per se. It means you can shoot a firearm, but it doesn't mean you can shoot it safely. So we wouldn't use that as part of the qualifications. And going along with the experience part, they've only had 2 years of experience compared to experts who normally have decades of experience. Therefore, they cannot be tendered as an expert in today's case.
Your Honor.
Well, I also thought the expert was already stipulated.
That is correct, Your Honor.
Yes,
Under stipulation, number 11,
I think so.
it states that Jackie Stock and Dr. Morgan Jay are experts, but it does not limit that they are the only experts.
Typically, you have to disclose your expert before you start. And further, it's highly unusual, although I could imagine a situation where it's allowed for the main testifying witness people to remain bathrooms and in an expert. That's a very that creates a lot of complications if that would be allowed. Of course, natural that is not necessary. Won't be good.
Yes, Your Honor.
Why did you decide to interview at Shooting Star?
Well, like I said earlier, I always had a hobby with guns. So when I saw that Shooting Star had a help wanted poster, I decided, maybe I'll turn my hobby into an actual job.
And what happened during the interview?
Well, interview was an hour long. Coleman asked me a bunch of questions.
Objection, Your Honor, you're saying? Yes.
Well, Coleman asked me a bunch of questions, and then eventually, Coleman made me fill out a form for a background safety check, and that concluded my time with Coleman that day.
And what happened after the interview?
After the interview, I waited 2 weeks, and eventually I got a call from Coleman. He said I got the job.
How were the first 6 months on the job?
Well, first 6 months, I was just a sales clerk. I managed the gun inventory. I spoke with customers about guns. I sold guns to customers. I just spent a lot of time with guns.
And what did you have to do to become a firearm safety instructor?
Well, eventually, I decided I wanted to become a firearm safety instructor. So I first had to get my firearm safety certificate, which I did in November of 2020.
And did Shooting Star have any positions for firearm safety instructors?
In November of 2020, no. I did have to wait till August of 2021 until a position finally opened up.
Now let's talk about the incident in May of 2021. What, if anything significant, happened in May of 2021?
I had a minor incident in May of 2021. I was inspecting a firearm when I was told that the barrel pointed towards the shop. I do not believe that happened. I would never point the barrel at another person or in an area full of people. However, I do understand that was a possibility, and because of that, I have to admit that it could have been my mistake, and I did face the consequences for it.
Did Skylar Coleman reprimand you?
Yes, I got a strict verbal warning, and on top of that, I got written up for it.
Was your finger anywhere near the trigger?
No, I never keep my finger on the trigger of a gun unless I plan to shoot. In that moment, I had no intention of shooting. I was just inspecting the firearm.
Were you pointing the gun at another person?
I was not. I do not believe I was.
And was the gun loaded?
The gun was not loaded. However, I still treated the gun as if it was loaded.
So did you learn a lesson?
Yes, I learned that from that point onwards, I need to be much more careful when I'm inspecting a firearm and watch where the barrel of the firearm is going when I'm inspecting it.
And did this incident hold you back from becoming a firearm safety instructor?
No, it was a one-time incident that occurred 2.5 years ago. And I never repeated this mistake again. So when I asked Coleman if I become a firearm safety instructor, he did promote me because I had all the credentials and the experience.
Objection, Your Honor, speculation.
Explain.
Your Honor, this is talking about how the witness Drew Cantrell is entering the mindset of Skylar Coleman of the reason why they are promoted. Therefore, it is speculation under the rule of speculation.
And Your Honor, witness was not going into why Skylar pardon, and under Rule 701, the witness may give their lay witness opinion. That should be a qualification.
Your Honor, this is directly going into Skylar Coleman's mindset because he didn't talk about what Skylar Coleman said. He said that he believed that the promotion was in turn because of his experience, and it talks about the mindset of Skylar Coleman. Therefore,
Well,
it
it's
is
about him
speculation.
believing that's why I was heard that committed. But with that being stipulated to the jury that can only speak to his experience and his belief in why something happened, I think he'd allow that.
Yes, Your Honor.
You may continue.
Can you restate the question, please?
Did this incident hold you back from becoming a firearm safety instructor?
Well, like I said, it was a one-time incident. I never repeated that mistake again. And I ended up getting promoted because I did have all the adequate credentials to become a firearm safety instructor.
Now let's talk about the incident in November of 2021. What, if anything significant, happened in November of 2021?
I had another minor incident occur. I left the gun range without first unloading the firearm. This was my complete mistake, and I face the consequences for it. Coleman rightfully punished me for this.
Were there people on the shop floor?
No, there was barely anyone there.
And did you learn a lesson?
Yes, I did. I should never leave the gun range without first unloading the firearm, even if I was planning to unload it right after. This mistake, I never repeated again, and yeah.
How were things after this incident?
Well, after this incident, Coleman gave me another strict verbal warning and also wrote me up again. This write-up came with a memorandum that said, if I were to repeat any of these mistakes, my position would be likely terminated. I love my job, and I didn't want that to happen, so I made sure to never repeat any of those mistakes.
Now I'd like to talk to you about the class on May 28, 2022, where Justice Carlo was shot in the leg. When did you first find out you were going to teach the class?
I found out in early May. I saw some emails between Coleman and Carco, and in those emails, I saw that Carco purchased a Glock 22. So naturally, I just prepared the course with the Glock 22.
When was the class scheduled for?
May 28th.
And what happened the morning of May 28th?
That morning, Carco came into the store. So I introduced myself to Carco, and I grabbed the Glock 22 and headed into the fire range with him and Nick Alvarez, where we went to stall 11.
And where did you position your student?
I positioned both Drew and Nick directly to my right. at an appropriate distance where they can both see my demonstration, but also be safe at the same time.
And what was your first step when teaching?
My first step was to give them safety equipment. I gave them goggles and I also gave them earmuffs. This is just basic procedure and I wanted to make sure to minimize the chances of them getting hurt.
And what was the next step?
The next step was to go through the 3 ground rules. First, never point a gun at something unless you plan to destroy it. Second, keep your finger off the trigger unless you plan to shoot. And third, assume that every, and I mean every, gun is loaded. On top of verbally demonstrating these rules, I also physically demonstrated them to make sure that both Alred and Carbo really understood them.
Did you give them any warning?
Yes, I also warned them about recoil. Basically, recoil is a kickback after shooting a gun. Bullet goes forward, gun goes backwards. As beginners, this might be something that's unexpected to them, or something that might surprise them. So I wanted to make sure that both Alred and Carbo knew of this ahead of time.
Did you teach them how to fire the gun?
Well, yes, after that, I went through my demonstration. I pointed the gun at the target and I discharged. Unfortunately, that's just when everything went wrong.
What happened next?
The gun had an unusual recoil. Instead of pushing my gun backwards, it redirected my barrel to the right. However, as a professional, I knew all I had to do was let my arm absorb the recoil and the issue would be solved. However, it was in that moment that Carbo just jumped up and his left arm hit my right arm, knocking the gun out of my hand.
Did you flinch?
No, I never flinched.
Did you pull the trigger more than once?
No, I only pulled the trigger once. And I don't know how the second bullet fired. I believe it fired after the gun fell out of my hand. It's just unfortunate that Carbo got shot in the leg.
No further questions.
Okay. Clarification?
Yes, Your Honor, but before we start, we ask for a brief time check from what's on paper.
29 minutes and 20 seconds.
Okay. Make Caleb ready.
Good afternoon, Mr. Cantrell.
Good afternoon.
I'd like to start by discussing your job experience. You started at Shooting Star in June of 2020.
That is correct.
You started as a sales clerk.
That was my initial position.
Later, you're promoted to firearm safety instructor.
That is correct.
However, you're not re-interviewed, correct?
I was not.
You did not get a second background check for this position,
No, I actually already got a background check when I first applied for the job.
and you didn't get any additional training from Shooting Star for this position, correct?
Well, not specifically as Shooting Star, but for me to get my firearm safety certificate, I did require training.
Now, let's talk about some of the rules at Shooting Star. Shooting Star does have a set of rules they have to follow in the gun range,
That is correct.
and you'd recognize these rules if they're shown to you.
I would.
Your Honor, let the record reflect I'm approaching opposing counsel was pre-admitted as exhibit A.
Sure, you can do that.
Your Honor, would you like a copy?
I already have it.
I already have exhibit.
Perfect. Now, Mr. Cantrell, please read Rule 2 silently while I read it aloud. Only point at it if you want it destroyed. Always keep the gun pointed downrange and never point a gun at anything you're not planning to shoot. I read that correctly, didn't I?
Yes, you did.
And Mr. Cantrell, you violated this rule in May of 2021, correct?
May of 2012. No, I did not.
However, you were reprimanded for this rule. Skylar Coleman claimed that you pointed a gun at someone, correct?
Yes, that is correct.
And I'd like to talk about November. Please read Rule 5 silently while I read it aloud. If it is loaded, leave it on the line. Check to make sure your firearm is unloaded, the action door is open, and the safety is on before bringing it off the shooting line. I read that correctly, didn't I?
Yes, you did.
Mr. Cantrell, you violated this rule in November of 2021 when you took a loaded gun into the shop floor, correct?
That is correct. And I deeply apologize for that. Coleman rightfully punished me for this.
And I'd like to talk about May 28th, 2022. You're teaching a lesson that day,
That is correct.
to customers, right?
That is correct. Howard and Carbo.
Taught this lesson at stall 11,
I did.
and you're gonna tell them how to shoot a weapon, right?
Yes, I was, on top of that, I was gonna go through all the firearm safety procedures that they should follow.
You position them immediately to your right,
That is correct.
and you went to shoot the fire, correct?
Yes, that is correct.
You shot it once,
Yes, just once.
and then a second shot fired, correct?
That is correct.
And this shot fire hit Justice Carbo.
It did Justice Carbo the leg.
Now, please read Rule 8 with me while I read it aloud. Know your target and beyond. Always know where you're shooting at and be mindful of what is around you and behind your target. I read that correctly, didn't I?
That is correct.
Now, on direct examination, you mentioned that Carbo may have bumped into your arm, correct?
No, Carbo did bump into my arm.
So you violated Rule 8 because you are mindful of your surroundings, correct?
That is not correct. I was actually quite aware that Carbo was next to me, and I assumed that Carbo was there where I positioned him. However, to safely discharge a weapon, I must be focused on the target in order to do that. It seemed to be in the middle of my demonstration that Carbo came closer, at least that's what I assumed happened. But I was aware that Carbo was to my right.
But you were mindful of them going to hit you, correct?
Well, no, it was after I fired the first bullet, and everything after that happened in a split second.
And just to clarify, you positioned where Justice Carbo would be, right?
I positioned where Justice Carbo would be, or where Justice Carbo should be. That was not where Justice Carbo was after I fired the first bullet.
Moving on, please read Rule 7 with me silently while I read it loud. Check your weapon. Always make sure your weapon is functioning properly cleaned, and safe to use. I read that correctly, didn't I?
Yes, you did.
And you violated this rule on May 28, 2022, and you did not check your weapon before the lesson, correct?
No, I actually did check the weapon beforehand. But just because I checked the weapon beforehand and it worked at the time, that means it was gonna work a few hours later.
Mr. Cantrell, is it your testimony today that you checked the weapon in May 28, 2022?
That is correct.
And you wrote an affidavit in today's case?
I did.
Your Honor, I'm approaching opposing counsel with been pre-marked as the witness of the affidavit.
You may, and in the interest of time, we don't need to ask for it.
Yes, Your Honor. You recognize this affidavit, don't you?
That is correct. This is,
Oh, yes, Your Honor. My apologies. Now you recognize that, you recognize this affidavit, don't you?
I do. This is my affidavit.
That's right, and the signature on the back of that page is your signature, correct?
That is correct. That is my signature.
And you're sworn to tell the truth and nothing but the truth in this affidavit,
That is correct.
and include all relevant facts in today's case?
That is correct.
Now, can you please point out to me where you say that you checked your weapon in today's case?
So on this page, I say that I'm familiar with Exhibit 8. And here I say that I always follow the rules mentioned on Exhibit 8. Exhibit 8 right here says, check your weapon. That is one of the rules. And in my affidavit, I mentioned that I always follow these rules. While I don't directly state that I checked my weapon on May 28th, I do state that I always follow the rules, which means checking my weapon before every session.
And you just stated that you always follow the rules, Mr. Cantrell, but you didn't follow the rules in November of 2021.
That is correct. And that's why I mentioned the only exception of me not following the rules earlier in the affidavit.
So you claim to check the weapon in today's case,
That is correct.
but you do not explicitly say that you checked the weapon.
I do not explicitly say that, but like I just mentioned, I do say that I always follow the rules, and this does include checking my weapon.
Moving on, Mr. Cantrell, I'd like to talk about the gun. Now, you received the gun loaded for your instructions, correct?
That is correct.
Thank you, Mr. Cantrell, and thank you, Your Honor.
Read rep,
Over here.
okay? Confirmed, you are dismissed. You may return to your team.
Thank you, Your Honor.
Okay, let's get the next person up. Minor, sorry, we're running a little low on time.
Is there a blue shirt in here? I just keep disconnected from Wi-Fi.
Yeah, we'll be here. to-
Okay, thank you.
But let's get the next witness.
Yes, Your Honor, the defense plus agent like this that.
Okay, you're up to be sworn in.
Please see, Your Honor.
You may.
Good afternoon. Can you please introduce yourself to the jury?
Hey y'all, my name's Avery Lynn. I'm from deep in the heart of Texas, so I moved to Imperium after completing my bachelor's degree at Georgia Tech.
And Ms. Nguyen, where are you currently employed?
Well, I work at Lexus, where I work with European-based countries in the morning and East Coast-based companies in the afternoon. They get a kick out of my accent.
And Ms. Nguyen, do you have any experience with firearms?
I would consider myself a gun enthusiast. My mama took me hunting for the first time when I was just 7 years old.
Well, would you consider this a hobby?
It's more than just a hobby for me. It brought me closer to my kinfolks and my family.
That being said, do you own any firearms?
Yes, I bought firearms both to collect and to use, so I've amassed quite the collection over the years.
Well, where do you purchase these firearms from?
I buy all my firearms from Shooting Star. They've created a private community after the new edition of their diamond.
Now I'd like to talk to you about your experience with the Shooting Star. In your experience, is the Shooting Star an organized place?
Sure is. Every time I purchase a gun, they make sure I follow every rule to a T. They always tell me, you know the drill, Avery. We gotta run the background check on you. Make sure you haven't picked up any case from last week. Which I never have, but they always ask.
And is the background check everything they do when you purchase a new firearm?
No, the store clerk always offers me a safety training course, which I always turn down due to my extensive experience with guns.
And does the Shooting Star have any safety officers?
Yes, they have safety officers roaming around, slipping gun safety handling tips to the newbies or anybody else that wanted to know. If they ever saw a violation, they would correct it immediately.
And Ms. Nguyen, do you feel safe at the Shooting Star?
I sure do, especially after Coleman took charge. He hired many more knowledgeable workers.
I'd like to talk to you about an accident that occurred on May of 2021. Was there an incident involving Drew Control on May of 2021?
Yes, there was a minor incident bringing an unloaded gun.
Well, was anybody hurt this day?
Absolutely not. The gun was not loaded.
And did Cantrell receive any reprimand?
Sure did. Coleman really ripped to the new one, and the scolding mister really got to him because I never heard this violation never happen again.
Now I'd like to talk to you about May 28th of 2022. Where were you on May 28th between 11 a.m. to 11:15 a.m.?
Well, I was posted up on stall 3, Avery's counter, the counter that they named after me. And the incident happened at stall 11, which is about 30 feet away from where I was.
And was anybody positioned between stall 11 and stall 2?
Nope, clear as a desert.
And what if anything significant happened at 11 a.m.?
At 11 a.m., someone walked into the shop and they introduced themselves to me as Nick Allred. He asked if there was any safety courses going on, but I said I didn't know nothing about that, but I saw something going on. We're on stall 11, so I pointed him that way.
And what if anything significant happened 15 minutes after that?
15 minutes after that, Carbo and Cantrell walked in the shop. We exchanged pleasantries and we went on with our day. They went over to stall 11.
And when they reached stall 11, how did they position themselves?
Well, they positioned themselves. Nick Allred the furthest to me, Carbo smack dab in the middle, and Cantrell the closest. But it looked like Carbo was crowding all up in Cantrell's business. I kept just trying to get a better look at what was going on.
Now I'd like to talk to you about the firing. Did you notice Cantrell do anything out of the ordinary prior to him firing the first shot?
No, everything seemed ordinary, like a classic training course.
Well, did you notice Justice Carbo do anything out of the ordinary when Cantrell fired the first shot?
I sure did. I saw Carbo jump after the first shot, and that caused Cantrell's arm to be pushed back, and that was around the second shot fired.
And what, if anything, significant happened after this?
After that, I heard Coleman yelling, call 911, call 911. And I waited while the paramedics arrived. I was wildly impressed with how Coleman handled his attack.
Thank you, Your Honor. I have no further questions. I pass the witness.
Okay, cross examination.
Yes, Your Honor. May I proceed?
Okay.
Now, Ms. Wynn, you have a personal connection with Shooting Star, correct?
Yes, that's true. I've been going for years. They've created a private community and I have my own camper there.
In fact, so you go there every weekend,
Yes, like clockwork.
and you would consider it a second home.
Yes, I mean, as I've said, like they have a private community there and I just really trust them over there.
And because you're a regular at the shop, you are aware of the basic gun safety rules posted around the range.
Yes, I am.
Because you're a regular, you have witnessed Drew Cantrell working in the shop.
Yes, I see him around, yes.
Now, you testified on direct examination to an incident in May of 2020, correct?
Correct.
In this incident, Drew Cantrell aimed a firearm at another employee.
Yes, I'm aware of that.
But that is not the last time you saw Drew Cantrell.
That I've seen him?
Yes,
No, that's not the last time I've seen him.
that's right, because you saw him on May 28th leading an instruction course even after this violation, correct?
Yes, I did see him.
Now, you testified on direct examination that during that safety course, nothing looked out of the ordinary, correct?
Nope, nothing looked out of the ordinary to me. It looked like a typical safety training course.
And you also testified that you saw Justice Carbo crowding Drew Cantrell during that safety course.
Yes, that's what it appeared, yes.
Ms. Wynn, now let's talk about what you couldn't see. It's true that you were not watching the safety course very closely that day, correct?
Yes, that's correct. You wasn't the only thing I was doing. I was working on customizing my lever action repeating rifle, but I could tell what was going on.
But it's true that you didn't really have a clear view of what happened that day.
No, I didn't. I mean, there was nobody there. It was a clear shot, but it wasn't the clearest view or the best view.
Right, and that's because you were standing in a stall 30 feet away.
Yes, but as I've said, I've been hunting since I was 7 years old, so I've got a great eye. But so I could really tell what was going on more than most people could. But no, I didn't have the best view.
And Ms. Wynn, before trial today, I measured the approximate distance of about 30 feet. You would say that this is roughly 30 feet, correct?
That is correct, yes.
So this is how far you were standing from the safety course on May 28th, correct?
Yes, around that, yes.
But Ms. Wynn, it's true that you were not facing the safety course directly, isn't that right?
That is correct. I was working on my own thing.
Exactly. You were facing your target this way.
Yes.
And you were watching the safety course out of the corner of your eye in this exact position.
Yes, that's true, but as I've said, I have a great eye and can tell what's going on.
It is from this exact position that you saw the entirety of the safety course on May 28th.
Yes, that's true.
Thank you, Your Honor. I have no further questions.
Any redirect?
Yes, Your Honor.
Okay.
Now, Ms. Nguyen, nobody was positioned between stall 2 and stall 11, correct?
No, it was clear
Objection, Your Honor.
business.
Leading question.
Reverse.
Your Honor, was there anybody positioned between stall 2 and stall 11?
No, there was nobody there, no.
And was there anything blocking your view from stall 2 to stall 11?
Absolutely not, no.
Thank you, Your Honor. I have no further questions. I pass it to you.
No, okay, you're dismissed, and, give us a second here in the and we want to get the next witness through. Okay, let's call the, final witness.
Defense calls Justice Law to exam.
Okay, Prosecutor Moran, you may be seated.
Please introduce yourself to the jury.
Hello, my name is Jackie Stahl, and I'm a firearms work examiner.
What is your work experience?
Well, for 7 years, I worked in the military as a on-field artillery officer. After I was on the discharge, for the past 11 years, I've worked in my own firm, Staff Examiners LLC.
What is your educational background?
I went to the U.S. Military Academy in Westport, where I received my Bachelor of Science in Physics and a minor in Photonics.
Do you hold any certificates?
As a matter of fact, I have 2 firearm safety certifications. The first was given to me by the Imperial Department of Justice, and the second was given to me by the United States Bureau of Alcohol, Tobacco, Firearms, and Explosives.
Pursuant to Stipulation 12, after the Islamic and Western Firearm Mechanics, and then based off their certification in the United States Bureau of Alcohol, Tobacco, and Firearm Explosives, a certification in firearm safety, and prior experience in teaching firearm courses, safety courses, I offer them also as an expert in firearm safety.
Yes, Your Honor, as we discussed earlier, as discussed by the stipulation, Jackie Staub is tendered as an expert in firearm mechanics, but opposing counsel did not tell us that they were going to be trying to tender them as another expert in firearm safety, and therefore that should not be tendered today.
As I laid the proper foundation, which I just did, I can offer this expert also as an expert.
The expert is tendered as a witness for what you stipulated. Please proceed.
Yes, Your Honor.
Now I must talk to you about your attention in this matter. What is your involvement in this matter?
I was retained by the defense counsel to give my opinion, best practices for usage.
Did you review any materials to prepare for this case?
Yes, I reviewed the deposition of Justice Goebel and Skylar Cole, the affidavits of Drew Cantrell, Avery Wynn, and Nick Allred, and exhibits 1 and 22.
Now I'd like to talk to you about your opinions on this case. What opinions were you asked to give?
I was asked to give on whether or not Drew Cantrell used the best industry practices while handling the gun on May 28th.
Objection, Your Honor. Improper expert opinion. As we've just established, this expert is
What are the industry's best practices?
The industry's best practices call for the operator to maintain a firm and still grip. This allows for easy management of recoil as your hand acts as a shock absorber, which directs the firearm back to its original position after being fired. If the operator has an overly relaxed grip, this can cause the gun to slip and inadvertently change point directions after the fire.
And did Drew Control follow the industry's best practices in the handling of the gun on May 28, 2022?
Yes, I believe Drew Cantrell did indeed follow the best industry practices.
What did you look at to determine if Cantrell followed the industry's best practices?
Well, I looked into whether or not Cantrell flinched prior to the first shot. If Cantrell flinched, the grip and point of the gun would have changed.
In your expert opinion, do you believe Drew Cantrell flinched prior to the first shot?
I believe Drew Cantrell did not flinch prior to the first shot.
And why is that?
Drew Cantrell, who is a certified firearm safety instructor, said that he didn't flinch. Avery Wynn, who had lots of experience with the gun and who was also present at the time of the incident, claimed that not seen any directional change in the gun prior to the first shot being made. Besides Justice Goebel, the only accounts of Cantrell flinching or twitching was Nick Allred, a newer gun buyer, who, just like Goebel, is a gun novice and probably couldn't tell the difference from a flinch to move from the recoil.
Now, at this moment, may I retrieve exhibit 1 from the previous table?
Sure.
Is this the Glock 22 you personally examined?
Yes, this is indeed the Glock 22 I first examined in this case.
Can you explain the mechanics of this gun?
Certainly. Because I believe that Cantrell didn't flinch. I believe that something other than user error must have caused the second shot and Justice Goebel in the leg. I personally examined this Glock 22 and thought that the most likely cause for the second shot that Justice Goebel in the leg was the overly tensioned screw right here, which was pressed by Cantrell to no fault of their own due to unrestricted violent recoil, and not caused by Cantrell flinching.
How do you explain what happened?
Simple. Accidents happen, even with the best of intentions and preparations.
What is your final expert conclusion?
I determined that the most likely cause for the second shot that Justice Goebel was the overly sensitive trigger, which pressed by Cantrell to no fault of their own due to unrestricted violent recoil, not caused by Cantrell flinching.
Yeah, and I public exhibit 1.
Any objections?
no.
Okay, you may publish it. Well, it's submitted as evidence and it's published.
No further questions, Your Honor.
Yes, Your Honor. Your Honor, may I retrieve the film from the witness stand? May I proceed?
Yeah.
You were retained by the defense to testify on whether Drew Cantrell followed industry practice on May 28th, 2022, correct?
Yes, that is correct.
But you are not an expert in gun policy.
No, I'm not.
You're not an expert in gun safety.
I'm not, but I have plenty of experience from my time in the military.
You're only an expert in the mechanics of firearms.
Yes, that is what I'm currently working with.
And now you want to solve all gun-related tragedies in the US, don't you?
Yes, that is
But you don't think gun laws are the solution
correct. No, they're not.
because you think gun tragedies are spurred on by incompetent people.
Yes, that is correct.
Just like someone sold a firearm without proper training, correct?
Yes, that is correct.
And now you looked at Drew Cantrell's lack of experience, correct?
Yes, I did.
And you found that Drew Cantrell worked at Shooting Star for only 2 years.
Yes, but besides those 2 years, he's also been handling guns since he was a child.
And within those 2 years, Drew Cantrell has had 3 safety violations.
Yes, that is correct.
One where he pointed a gun at another person in the store.
Yes,
One where he left a loaded firearm in the store.
yes,
And one where he shot another person in the leg.
unfortunately, yes.
And now I'd like to talk about your analysis of today's case. You reviewed the Glock 22, correct?
Yes, I did review the document too.
I'm like the one who put that and showing the witness what is being put. And this is the gun that you evaluated in this case, correct?
Yes, it is.
And as an expert in firearms, you didn't test this gun, did you?
But I did examine the gun.
You examined it, but you never fired this weapon that you came to a conclusion on.
No, I did not.
Thank you, Your Honor. I have nothing further.
Okay, redirect. Any redirect?
No redirect, Your Honor.
Okay. You are dismissed. Quick question, frankly, how much time did you slide that?
The prosecution has 17 minutes.
Okay, so we can take a 5-minute break now. But, we only have like 40 minutes left. So, yeah, we're 43 minutes left. We have a 5-minute break, but it's like hard 5 minutes. Hard 5 minutes, so we need to go. Restart time. Okay, 5 minutes up, so let's get moving, this jurisdiction, the plaintiff's benefits, so the argument first. Counsel for Justice Carbo, how much of any time is reserved for rebuttal?
Your Honor, may I just reserve any time I have remaining after my closing argument?
You may,
May I proceed, Your Honor?
you may speak.
Violations and retention led to devastation. Now, members of the jury, throughout trial today, you've been given a lot of information. Information about a safety course that took place on May 28th and the devastation that occurred there. You've heard from multiple experts, multiple witnesses about the firearm safety, or rather the lack thereof, during that safety course. Members of the jury, you now know that Justice Carbo, looking to buy and learn how to properly use a firearm, went to Shooting Star Gun Club, trusting that they would be able to properly do their jobs. For members of the jury, instead of that, Justice Carbo was shot in the leg. Shot in the leg by the very person who was supposed to be teaching her firearm safety. Now today we as the plaintiff held the burden of proof, but we had to prove to you by a preponderance of the evidence the negligent retention, hiring, or supervision of Drew Cantrell. That's simply meaning we had to prove that this was more likely than not. And we did this and we met this burden. And first, the violations. Throughout trial today, Dr. Morgan Judd, an expert in firearm safety, talked to you about the multiple violations that Drew Cantrell committed that even a beginner, not to mention a professional, should be able to follow basic rules. Throughout trial today, two specific instances have been brought up multiple times. An instance in which Drew Cantrell aimed a firearm at another employee at Shooting Star, and an instance where he left a loaded gun on the counter in the shop with customers and employees present. Now today, we called Ross Hernandez to the stand, who testified to both of these incidents and the lack of action that was taken by Shooting Star following them. Today, Drew Cantrell himself, on cross-examination, admitted to violating multiple of those rules, yet he is still working at Shooting Star today. Now, members of the jury, despite physically pointing a gun at another person twice now, Drew Cantrell still teaches firearm safety courses. Now, ordinarily, you might think a company who, according to their policy, practices and values safety might do something like re-interview Drew Cantrell, make sure he undergoes more basic training, reevaluate his fitness as an employee, or suspend his license. But members of the jury, what did they do instead? Promoted Drew Cantrell. Promoted Drew Cantrell to a position in which he would teach firearm safety to beginners. Firearm safety, the very thing that Drew Cantrell himself was incapable of. Now today, the defense calls Avery Wynn to the stand. However, all she was able to offer you was testimony based off the corner of her eye from 30 feet away that members of the jury is truly not that reliable. She told you today that she considers Shooting Star her second home, so of course she would find nothing out of the ordinary about Drew Cantrell violating the rules in today's case. Now today, the defense called Jackie Staub to the stand, and he told you that gun safety violence is caused by incompetent firearm users who lack training. Members of the jury, incompetent firearm users like Drew Cantrell, who has committed multiple violations. Members of the jury, Dr. Judd stood before you today and read you the last line of Exhibit 8, which states that if any of these rules are violated, further shooting privileges will be denied and there will be a removal from the range. Members of the jury, no such thing occurred. Instead, Drew Cantrell was hired to a position in which she would be in the range every single day. In no way was she denied future shooting privileges. Members of the jury, I want you to remember today that the violation of these rules by Drew Cantrell and the retention of Drew Cantrell following those violations led to the devastation that brought us here today and the devastation that will affect Justice Carbo for the rest of his life. Find the defendant liable. Thank you.
Thank you for your argument. Shooting Star Gun Club, you may proceed.
Your Honor, I would ask that our counsel is also able to see this demonstrative during closing if that is possible.
Sure. You may move wherever you need to be.
Accidents happen even with the best of preparation. May it please the court. You heard today that Drew Cantrell has grown up using guns his whole life. He is a certified gun safety instructor. He holds a certificate in firearm safety and has taught gun safety courses. It is undisputed that he had 2 minor safety incidents in his entire employment, but no one was hurt. He learned his lesson and he never committed those safety infringements again. Now I'd like to talk to you about the law. We raised 3 affirmative defenses. You heard today that the accident was Justice Carbo's own fault and not the fault of Drew Cantrell. Justice Carbo was shot in the leg because they moved out of their position and flinched, which caused them to hit Drew Cantrell's right arm. There was an intervening and superseding cause, because after the first shot, there was a strong recoil and the gun had an overly sensitive trigger, which caused it to go off a second time. Finally, Justice Carbo signed or released a hold harmless agreement in which he knew the risk of participating in a hazardous and dangerous activity. We have the burden of proof with these affirmative defenses, and we gladly bear this burden. Now I'd like to talk to you about the negligent in hiring claim. My client is only liable if he knew or should have known that Drew Control, if entrusted with a firearm, would be unfit or incompetent, or that incompetence caused a risk to others. Further, they have to show that the incompetence or unfitness harmed the plaintiff. And as we saw today, Drew Control is not unfit, and Justice Carbo caused his own injury. The plaintiff had the burden of proof to prove their case by a preponderance in the evidence, and they did not meet their burden. Now I'd like to talk to you further about the negligent hiring claim. Drew Control is not unfit or incompetent. In all of his years working at Shooting Star, he only had 2 minor safety incidents. You heard today that he learned his lesson and he never committed those safety infringements again. You heard Drew Control say that Justice Carbo moved too close to him. And also that Justice Carbo flinched, which caused him to hit Drew Control's right arm. Jackie Staub, an expert in firearm mechanics, said that the gun had a strong recoil and an overly sensitive trigger, which caused it to go off a second time, directing the gun towards Carbo's leg, shooting Justice Carbo. When you go back to deliberate, you will be asked 5 questions. Did Shooting Star gun clubs negligently hire, supervise, or retain Drew Cantrell? The answer here is a resounding no. And if for some reason you move on to question 2, did Shooting Star gun clubs negligent hiring, supervision, or retention of Drew Cantrell directly and proximately cause Justice Carbo's injury? Drew Cantrell did not proximately cause Justice Carbo's injury. The answer here is no. Was the harm suffered by Justice Carbo more attributable to wrongful conduct by Justice Carbo than any wrongful conduct by Shooting Star? Justice Carbo caused his own injuries. Therefore, the answer here is yes. Did Justice Carbo either expressively or impliedly know the risk of injury and voluntarily proceed in the face of risk? Justice Carbo signed a release of liability and hold harmless agreement in which he knew the risk of participating in a hazardous and dangerous activity. Therefore, the answer here is yes. Was there a new independent clause that broke the chain of proximate causation between Shooting Star and gun club's negligence and Justice Carbo's injury? Again, the gun malfunctioned due to a strong recoil and an overly sensitive trigger. The answer here is yes. Members of the jury, accidents happen even with the best of preparation. Drew Cantrell was prepared to teach the class. Justice Carbo moved out of their position and flinched. The gun malfunctioned due to a strong recoil and an overly sensitive trigger. Accidents do happen. Thank you.
Okay. Can the timekeeper please let us know how much time Council Carbo has for the rebuttal?
Council Carbo has 12 minutes and 52 seconds.
Okay, you may proceed.
Your Honor, I would ask that opposing counsel would leave up their demonstratives so that I may be able to reference them as well.
Okay.
Okay, I've already marked this one. Accidents happen even when you are prepared. And that is what the defense counsel has told you today, but what they have not told you is that Shooting Star wasn't prepared. If Shooting Star was prepared for what happened on May 28th, it never would have happened at all, because Drew Cantrell would not have been employed as a firearm safety instructor when he himself was in violation of those rules in multiple instances. Now today, multiple witnesses on the defense counsel have told you that the gun that was used on May 28th was loaded when Drew Cantrell brought it into the range, excuse me. He brought it into the range from the gun shop from Skylar Coleman, who sold that firearm to Justice Carbo. The members of the jury, the gun was loaded in the shop. I would like to refresh your memory of Exhibit 8, which states that always keep your firearms unloaded. Members of the jury, if the owner of Shooting Star, Skylar Coleman, cannot even adhere by his own rules, how can his employee and firearm safety instructors be expected to adhere to them as well? Now, in openings today, the defense told you that the devastation in today's case was Justice Carbo's own fault. But Justice Carbo did not violate the safety rules. Justice Carbo did not flinch prior to the shot, and Justice Carbo did not shoot himself in the leg as a result of negligent retention. Now, today in opening, the defense counsel told you that Ross Hernandez will offer nothing. Members of the jury, this is what the defense stood before you and told you at the start of trial. However, what they offered you was a reliability form, which according to the case law in today's case, does not bar the plaintiff's negligent claim. This case law in today's case is already laid out for you that the liability waiver is not a sufficient defense to the negligent hiring and retention of Drew Cantrell. This is possibly why the defense took on 3 affirmative defenses, of which they have proved none. However, we have met our burden. First, did Shooting Star Gun Club negligently hire, supervise, or retain Drew Cantrell? Yes. You heard today about 2 incidents where Drew Cantrell blatantly violated Shooting Star's policy and was not removed from the range as Shooting Star themselves said he would be. The retention of him as a firearm safety instructor and the appointing of him to lead that course directly led to the gunshot in today's case. Negligent retention. Second, did Shooting Star Gun Club's negligent hiring, supervision, or retention of Drew Cantrell directly and proximately cause Justice Carbo's injuries? Members of the jury, the only plausible answer is yes. As I previously stated, Justice Carbo did not assume the risk of being shot in the leg and did not assume the risk of being taught under a negligent and reckless firearm safety instructor just because they signed a liability form. Members of the jury. Point 4 states that if assumption of the risk, did Justice Carbo either expressly or impliedly know of the risk and injury involuntary proceed in the face of risk? Members of the jury, how on earth was Justice Carbo supposed to know that a shooting club who claims that they know how to teach firearm safety would shoot them directly in the leg? Members of the jury, no liability form is going to make up for that or account for that matter. Finally, if interviewing and superseding cause, was there a new independent cause that broke the chain of proximate causation between Shooting Star Gun Club's negligence and Justice Carbo's injury? Now today, the defense tried to tell you that the gun malfunctioned as a result of a light trigger and a recoil. However, how would they know that if their expert who was testifying about this gun didn't bother to test the gun at all? They simply looked at it and somehow knew that the recoil weeks ago, months ago was light, and that the recoil was extreme and that the trigger was light. Members of the jury, that is simply not plausible. Once again, the plaintiff had to prove to you by a preponderance of the evidence of the negligent retention, hiring, or supervision of Drew Cantrell. Members of the jury, we have proved that version. Justice Carbo told you today that the only thing he would have done differently is to have never gone to Shooting Star in the first place. Now, Drew Cantrell was told to include all relevant information in today's case, but clearly he did not, as he didn't mention Skylar Coleman handing him a loaded gun in direct violation of Skylar Coleman's ordinance. Members of the jury, how can opposing counsel say that Carbo assumed the risk, but additionally an outside and superseding cause that they couldn't foresee caused the gunshot? Now, how could two of those things be true? Members of the jury, the answer is because it's not. We have proved our burden, and Drew Cantrell is the direct cause of the harm that was done in today's case. Members of the jury, please do the only thing possible and find the defendant liable. Thank you.
Okay, we thank you so much for your presentation today. The judges are going to take a few minutes to complete our ballot. You need to use the restroom, feel free. But please come right back if we're going to do. So, hey guys, please hold up. Get finished off, but don't get final. Yeah, ask, they can ask their question. I've known, if you want to ask Gary or
So you guys know how to distinguish sports. Each want its teams to introduce themselves.
With nominations. But you know.
Okay.
Oh, you'll see that. Oh,
Yes. Very smart, that's very smart.
Okay.
Yeah.
Okay, looks like all ballots are completed, you guys can vote.
Okay, is everyone ready for the comment? So how we're gonna do this is, I'll start or introduce myself, give my comments, and we'll go around with the other two judges. We'll try to keep this kind of short because obviously we all have to play this game later. So to start with, my name is Dylan Tilbury. I am a practicing attorney in Chicago. I worked as a judicial law clerk for 2 federal district court judges and the Supreme Court justice in Michigan. So I've been involved in trials. I've worked with the judge during trials, both case and jury trials. And, I work on cases now as an attorney, as a kind of do what you guys do, although not always as exciting. I think overall it was a really good job. These are pretty complex things you're being asked to do in terms of arguing case law and effects and, like we talked about earlier today, having to argue the motion in limine. Those are really difficult things to have to do. In terms of areas for improvement or, just things to think about going forward, I think it's important everyone kind of make sure that they are very much paying attention to rules of evidence and the cases. Now, especially with the rules of evidence, most, some of the attorneys that are judges know them, but the thing is, like, there are some differences with the rules of evidence. between this and the real one. And you know, some people don't practice in federal court much, so they may not be as used to the rule. You know, they may be used to slightly different rules. Most states adopt federal rules of evidence, which is what we have here in Imperial as well. But it's just as important to make sure that you have the rule and say the rule and explain the rule. And I definitely recommend making sure you stay up to date on all the cases. I know that came up a couple times today, but we kind of had, you know, one reason it probably took a little longer is we kind of went back and forth on stuff for a bit, where I think if we had been able to get the case faster, you know, that can really clear it up. So the example of that is like the waiver issue. So like with the waiver, you know, what the case says it is in the bar, but it still is able to be brought in, or like with character evidence, it has to be kind of the other way around. Like with character evidence, there's cases that very clearly says that character evidence is allowed. As long as you do the notice, you are allowed to go through the party character evidence because it's an element of negligent hiring. You have to be able to talk about why someone was doing something bad to explain why it's bad that they were hired. Otherwise, you can't affect that. So I do think that's kind of an area to work on. I think, you know, I'd be a little bit careful with things like the expert, trying to certify extra experts. I've seen it work before, so some people will accept it, some people won't. So, you know, take what I'm saying with a grain of salt. But I think first of all, like Cantrell is, I would say no to Cantrell. I think I've seen cases, so we did a case in Empire 2 years ago that involved a FBI agent as one of the witnesses who put together the case. And I saw someone trying to certify them as an expert, and I think I overruled that where I declined to certify them due to the fact it's not stipulated because there's no report. Because strictly speaking, an expert usually has to have some sort of report or some sort of thing that they can kind of key off of. Otherwise, it's just random opinion. But further than that, I think with Cantrell, it's really hard to do Cantrell as an expert because he's not exactly the party involved, which is like the one way you might be able to get away with it. He's the key factor. And